I handed over, that was addressed to me, but the advocate on record is my junior. So my lord had been pleased to.
Should I take that on record?
Not I leave unto your lordship.
No, you tell me, because it will be your call ultimately.
My lord, your lordship can.
Since it's withdrawal, you will be responsible by the recording.
I appear on behalf of the CAC in this.
I'm on the behalf of the petitioner, Your Lordship. Your Lordship, matter is relating to the unauthorized transfer of the electricity meter of the petitioner's husband, who is deceased now. On last occasion, the private respondent seek the adjournment.
Only on 2 points, my lord. But in the writ petition, my lord will come kindly peruse the paragraph 6 at page 4, wherein the death of the husband of the petitioner has been stated on 24/5/2020, and we have filed a report on the last occasion, my lord. My lord will kindly peruse the annexure, my lord, A1, the third A2, my lord, wherein the private respondent, while applying for the change of name, has given consent of the deceased husband on 19th of
P1.
November.
my lord, annexure A2, my lord, the last annexure, my lord.
Annexure A2 to what?
A2 to my report, my lord.
To your report. A1.
The last page of the that is A2.
19/11/2020.
Yes, my lord.
Yes.
Given the consent and 19.
Yes, that is what he indicated,
Yes.
that it was
And my lord, only
consent
one
was taken of a dead person.
Yes.
Regarding this title, another civil suit is pending by regarding the title of tenancy right. Another
Take the mic.
regarding of the title of the tenancy right.
But how does this transfer stand? The transfer is apparently has been taken in the name of a person who is dead, and you have obtained the person's consent after the death of the person. How can that be possible?
My humble request is that any decision taken by this court that does not affect my civil suit.
It will not. The transfer has to go. The transfer has to be annulled.
But that finding must be recorded, Lordship. My humble
finding of what? Why did you take this transfer first? Don't expect any finding when you yourself are not with clean hands. You have obtained a consent of a person who is dead after the death of the person. How can that be possible?
Yes, Lordship.
So therefore, you don't make any further prayer. Otherwise, your client will be in problem. Don't make these prayers. He should not have done this at the first instance. When the person is dead, how could he do this?
Only 2 things I will submit, my lord. My lord will kindly peruse my report, page number 2, my lord. My lord, we can transfer it in the name of the.
We have to transfer it back.
Will upon compliance of all formalities.
What more formality? Formality. He did not apply for transfer. You transfer it by changing it back. He will not do anything else, because he has already been put in trouble because of your mistake.
No, my lord.
Yes.
name of the
By
consumer.
order of the court, Mr. Mukherjee, you have to do that because he cannot unnecessarily be troubled.
No, my lord.
Somebody has cheated him, and what formalities will he
My lord,
undertake?
we were also being,
Very well. So you deal it with him. Don't put him in trouble.
but my lord, I can transfer it in the name of her husband who has expired, but I
Yes,
want
that
to,
is,
but I want to transfer in the name of the wife, my
you
lord.
want
Okay,
your
okay, no issue, your lordship.
That is
to
the
apply.
reason. That
Yes,
is
your
the
lord.
reason. Let him later apply, and upon compliance, we'll do it. And my lord, only one thing, last occasion I have submitted the report that has not gone into the order. My lord, let that be clarified, my lord.
That did not go into the order because I wanted him to take instruction about it. Because if I had taken this on record, then it would have gone on that itself, point itself. Yes. Who are you in respect of the premises?
The brother-in-law.
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 And you are?
Sister-in-law, your lordship. The brother's husband. Yes, your lordship.
He's the
She
The wife of the
is the wife of the deceased and the
brother.
the brother of the deceased.
Brother of the deceased. So the respondent is the brother-in-law of the petitioner.
Yes, your lordship. In-laws.
Very well. It has to go in his name.
matter has been referred to here. My lord, I have got one most urgent matter because of the fact your lordship will find this matter was fixed for evidence. Thereafter, I communicated through daily list that matter is pending before the Honorable High Court. Trial judge rejected the prayer and closed the evidence. Thereafter, on the very day, fixed up the argument as last chance. And that date has been fixed on 31st, my lord.
31st, you have time.
My lord,
Tomorrow the bench will
urgent
be
matter
available.
listed before.
Tomorrow the bench will be available. It is not that urgent that it cannot wait till tomorrow.
This
Only
is
for
sep-
today
this
it
is-
is there
this is-
which
these
called-
two matters are separate matters, my lord.
Whatever it is.
70% of the proper decretal property has been taken by
Very well.
the writ of
All of it
possession.
can be addressed tomorrow. It is not that urgent that it has to be taken up today itself.
My lord,
Unnecessarily don't mention.
my lord, the place for
The
leave.
determination is only for one day.
Item number 3, Lordship, I am for the petition. Lordship, petitioner is the occupier and permanent resident, Lordship, applied for a domestic connection before the CSC authority, new connection, Lordship, having all the occupancy documents in the name of the petitioner. Lordship, thereafter, the CSC authority has issued the letter dated 21st July 2026, page 11, Lordship.
You are not getting supply.
I am not getting supply, and the said letter does not disclose any meter number or the name of the consumer from which I am enjoying the electricity, only a letter.
Lordship, we got an instruction that that he's enjoying electricity from his grandmother, and the
Then
meter.
You have to inform him.
Yeah, that I couldn't find
Lordship,
anything, any
what I am
communication.
praying at this is let them make one fresh application and to file a report, Lordship, whether I am getting supply or not, Lordship.
File a report.
Lordship.
Be
Lordship,
better. He will also come to know.
Lordship.
Lordship.
लिखे नहीं. Next.
Yes, my lord. I am for the petitioner. This is not the case of the billing dispute. This
In the
is
case of
billing dispute. No billing dispute case no disconnection notice issued by the WBACDL. But in the premises of the petitioner, 79 years old, there is no electricity. This is a question of the maintenance. Maintenance of electricity line, because it is the property of the licensee.
That is, the line is lagging. The line.
Yes, my lord. My lord, kindly come. Firstly, I am orally submit that I see in the 12th December 2025, few person, unknown person, my story is that few person come to the poll and they are working something what is thereafter no electricity in my premises. Means there is a somehow disconnection. I made an application before the local office customer care center. My lord, kindly come to page the representation given by the there. Firstly, my lord, come to page 13. That this connection is 2009, my lord. Kindly come to page 13, my lord. That is the meter reading and the connection, the meter card.
Problem, Mr. Bandyopadhyay?
The story is totally different. But he perhaps is a tenant. He was a tenant.
No.
But the landlord evicted him. There was an eviction suit. He, by virtue of the in compliance of the court's order, my lord, with the help of the police, my lord, he was evicted. The entire building was demolished in presence of the police and the, my lord, the WBCDSL authorities. And my lord, the meter room, that was also, my lord, in a very dangerous condition, and we had to remove the meter also. And he is, my lord, my instruction, he is staying, my lord, staying there with, my lord, triple set. My lord, there is nothing. No connection can be given.
Connection can be given.
Yes,
if you don't have a premises, how can electricity connection be given?
No, my lord. This is no eviction suit, no eviction order produces that. No, my lord, letter, my lord, letter kindly see. The writ petition is pending. Your party is there. You will say.
Copy can't be like that.
Number to bolu.
আমি দেখে পড়ি তারপর দিচ্ছি। Ajay, this is a injunction not to disturb the peaceful possession in the last possession. Honorable Justice Kaushik Chando in the Group 5 matter Panchayat.
Yes.
Yes.
So how can electricity connection be given here? Without any brick wall, you have a corrugated tin shed structure.
Yes.
How will electricity
Yes.
connection be given there?
2009, I am
Not yes. How
Without
will
any brick
electricity
wall.
supply be given here? This is not a premises. You have to have a premises for electricity supply to be
no,
given.
my lord. That is a premises, my lord. That connection was given, my lord, 2009, my lord. Kindly see that page 13.
Been given in 2009.
Yes, my lord. Page 13, my lord.
The bills.
Page 13, my lord.
The bills which you show, last bill is of 2013.
Payment, all payment, my lord. All paid, my lord. That is, if so, my lord, kindly see the bill that I have paid, my lord, page 15, my lord. Page 15 and 16. Bill has been paid, they have raised the bill. Then their story is a new story.
Mr. Bandyopadhyay, page 15. How can there be a bill? November 25 to January.
Yes,
20.
yes, my lord,
Please
obliged. Oh, yes, my lord.
Period, my lord, November to January.
Yes.
If he has paid, but my lord,
if he doesn't have a connection, how will he pay?
yes,
Then?
My lord, I don't know when that incident occurred, when he was evicted, that I exactly don't know. But he has not even disclosed in his
Then
petition.
Next page 16. 27th February 2026.
I will take instruction or your, my lord, I will file a report.
The petitioners complains of inaction on the part of the WBACDCL authority in not maintaining the electricity line
acquire by obtaining, by creating forged deeds. They obtain loan in the premises where I am residing, imposing my property as a collateral security. I am no way connected with the loans, and the bank has served notice upon me for vacating. The loans become NPA naturally because they engage my property in the schedule of their deeds. My property has been written as their property, and loan has been obtained in connection with and or against my property.
What is the property?
Property, I purchased the property and developed it through the promoter. They
When did
execute.
you purchase the property?
Malad,
When did you purchase the
I
property?
purchased long back, Malad. The deeds I have annexed.
No, man. I just wanted to know the date.
Malad,
Year.
Malad, I'm coming, Malad, 1 second. And 2021.
2021, you should have then checked up the portals.
Yes, that is in my name.
If it is equitably mortgaged.
Equitable mortgage created thereafter, after my purchase and development of the property. I developed it through the promoter. They purchased thereafter in 2024. They execute not purchase. They executed the forged deed after 2024.
Executed forged deed of what?
Forged deed saying that they have purchased my property
From you.
from me.
So then how will writ court decide this?
No, I will satisfy lordship.
To go before a suit court then. How
No,
will
Lord,
this
suit has been filed.
So stay, obtain an order of injunction there.
Those have been filed. Lord, I will satisfy the immediate after the immediate after that, because the banks have issued several notices for vacating the premises.
Obtain an order of stay, but how will writ court
I will satisfy what is the difficulty.
disputed question of fact? I will not.
I will satisfy.
Serve the other respondents.
I have served. Only 2 are yet to receive. Only 2 private respondents are yet to receive. Other all have been served.
So many banks are there.
My lord.
All banks have granted loan.
My lord. 3 private respondents obtained from 3 different banks.
I'm not satisfied with the maintainability, entertainability.
I will try to satisfy.
Questions of fact, how will I know he has executed or not, you have executed or not, your signature is there or not? How will these questions be decided on the basis of
I will try to satisfy. Let all of them come. I will try to satisfy.
How will I know so many respondents? Your receipts are at one place. Your postal track record.
No, in a serial, in a serial.
Serial means you should have pasted it on that only. How will I match?
The may I file a fresh one?
It becomes difficult. 11, 12 parties. How will I? Half an hour will be lost in that.
No,
you should have.
Don't take trouble. I will come up with a fresh one.
Pasted it on that only.
Fresh one, so that it can be it can be sorted out easily, Milord.
Yes, please do that.
I will, Milord. In course of
I used to do that when I was on that side because I heard it from Justice Dotto, and that is very very convenient. You paste the postal receipt on the postal track report,
so that it can be identified properly.
Yes,
I will, Milord.
That becomes easier for you to identify.
I will, Milord. Well, in course of the day, I will file it.
Then you give it. I'll take it on record. Since they are not appearing, I will in any case direct fresh service. I will not take these kinds of matters without their appeal.
to disputed bill. Dispute bill, disputed bill. Issue is related to disputed bill, electricity bill. The petitioner,
It is related to disputed bill. Why don't you approach the grievance redressal officer?
my lord, by electricity has been disconnected by the time, and statute says, statute is clear, till such time, there is a pending of representation before the concerned authority, on protest, they can collect the bill of average 6 months, and electricity may not be disturbed.
You have approached the
Kindly takes up, I have two representation made, before the authority concerned, the representation that at page.
Grievance redressal officer. So you have to approach. Grievance redressal officer is a separate authority that you have.
No, kindly see, page 37 and page 41.
Who is appearing for the licensing? How have
Yes.
you served? Affidavit of service?
Let me ascertain from it. May I serve and come back?
Why did you file without serving? The petitioner is unable.
Lordship,
I beg to appear for the Ombudsman, Lordship, WBRC.
Lordship, I have filed this writ
Appearing
petition
on
as the ombudsman is not working at this stage. That is why I have filed this writ petition, Lordship. I have also annexed.
Where is the ombudsman?
Lordship, kindly sees the last.
Ombudsman has limited his office. Yesterday, a new person has been appointed as Ombudsman.
Appointed.
He is going to take charge
Lordship,
in the next week.
I have already filed this writ petition. Kindly.
I will remit back to the ombudsman. He has joined. His submission is there. Unnecessarily, why should writ court? All of you will be losing a forum.
Lordship, then kindly what I am praying, there is some urgency, Lordship. The entire building is without electricity connection, Lordship. I'm praying within 1 month the representation be disposed of, Lordship, by the ombudsman.
You have made the representation.
Yes. They have also replied that the ombudsman is not in progress. That is why they will.
Mr. Saha says that ombudsman.
Lordship, kindly sees this annexure once, Lordship. The last annexure. It starts.
Representation, the appeal before the
Yes. The appeal against the order of the GRO we have filed, and they have replied, page number 32, Lordship, of the writ petition.
But the Ombudsman is in.
I am directed to inform you. Yes.
Of the matter. Thereafter,
Date of hearing will be
Then I am directing him to dispose of the new.
within 1 month, Lordship, kindly. That is what I am praying.
After granting opportunity of hearing.
Yes.
That is there in the statute.
Yes.
I mean, the regulations.
They have filed their initial report also before the.
Yes, but
That is
ombudsman was not available.
This writ petition has been filed
Kindly do not scold me, my lord. Petition, my lord. Urgent determination of justice.
Tomorrow it will be available. Tomorrow
The matter
bench
is,
will be
my lord, the possession is going to be taken up tomorrow. My lord,
Order is passed 1 month
my
back.
lord, the possession is.
They sat tight.
Mr. Bhattacharya, tomorrow the court will be available. Doesn't look nice. Tomorrow the bench will be available. It's only for today.
My lord, kindly do not go by Mr. Chatterjee's submission. My lord,
No, I have seen the determination list. It's only for today.
yes.
Tomorrow the bench is available.
Well, I was only beseeching your lordship, my lord, if it any time commends to your lordship to take it up today, my lord, it's covered by one of your lordship's orders also. My lord, in the revisional jurisdiction.
His order is under challenge directly before the divisional court. They
But
have
yes.
similar about 50 crores. They don't want to go to the DRM after
My
one
lord, I
order.
do not know. I
Yes.
do not know, my lord, how he is. Who is he?
I am the auction purchaser.
My lord, he is the auction purchaser, my lord. He has not been put into possession.
Mr. Bhattacharya, tomorrow the bench will be available. DRT matters.
DRT matters are he?
Yes.
I'm for the state, your lordship.
What?
My lord, we can say, my lord, we ignore it. In Bengali, whatever we say, ignore.
Lord, he's the Prabhu. He can say anything he wants to.
No, to my friend, not to the
Anyone.
honorable judge.
Honorable judgment, I can't say anything, but
The
to
notice has
humans,
been
I can.
at least 10 days back. Tomorrow is the date of possession. Now they are referring.
Yes.
But for new connection applied, page 14 is my application, and I was directed to make payment, the quotation. On the next page, I made that payment also, my lord. But now they are denying to give new connection on the allegation, lordship. Page 14 is my application.
Yes.
And page 15 is my lord, the payment receipt. According to the direction, I paid the amount. And now they are denying my connection on the ground that there are some previous dues, not by me, but the previous, I don't know who is he, from who the recovery should be made. Let them proceed according to law to recover from them. I have got no connection with that person. I am the new owner. I purchased the land, I am Vastu, and I have been residing there with my 85 years old mother-in-law. And they failed to establish their case from when the due is there, whether it is barred by limitation or not, and what is the nexus between the petitioner and that particular person. No, nothing has been disclosed. Only they are saying that as there is due from such one person, so you have to pay that same.
And you are what, subsequent purchaser?
No, I am the owner. I got it from my father-in-law. My name has been recorded in the record right also.
And whose dues are they claiming?
They are not disclosing who is that particular person. They are simply saying that there is a due.
Just now I have been told that the brief has been received in the office by today. Lordship, kindly grant me, kindly keep it up in next week. I will come with a concrete instruction, Lordship.
Yes, but you have to inform him whose dues you are claiming.
Yes.
Why
I will take instruction. Whether the information has been given or not, I will certainly take instruction because I am not aware.
Sahid Ahmad, some Sahid Ahmad's dues.
What is the nexus between Sahid Ahmad and this particular lady?
Nexus also is not given. That should disclose nexus.
I will.
From when that is due, whether it is barred by limitation or not, whether they took any procedure for recovery of that particular dues or not, nothing has been disclosed. There are certain courts that they should have to follow for recovery of the dues, if there is at all.
The petitioner complains of arbitrary action on
New electric connection for domestic purpose. Petitioner has all the occupancy documents, Lordship.
Well, there are two issues here. Number one, during inspection, he could not identify us a position. And secondly, my lord, he's already enjoying supply. This is
No letter was produced to us, nothing, Lordship.
true letter. We have already communicated, dated 26, 2026. We've sent the communication to him.
Lordship, kindly let them produce any document of communication, Lordship, to the petitioner, Lordship. They are stating that
Letter which we have.
no, the mode of communication to the petitioner, kindly, Lordship.
Well, this is the current situation. He's enjoying a supply.
Lordship, I have not.
But
Identify.
should inform him, this letter like this won't do. Please inform him by the, so that he can take appropriate steps. Once he comes up in writ petition, you show a letter.
And Lordship, my instruction is that petitioner is residing in the first floor of the said premises, having no electricity connection. The first floor has been constructed newly, Lordship, after the marriage of the petitioner, Lordship. And the said first floor has no electricity connection. Lordship, let them conduct one fresh.
Inspection can be held to assess the position.
Lordship.
That will be better. And 3 weeks' time may be given to us.
The petitioner complains of
Petitioner is praying for new electricity connection and a joint inspection report and the joint inspection was held, and the report says that by erecting two lower extension distribution poles, the electricity can be provided to my premises. Now the private respondents are restraining them to provide the electricity connection. That is why I
Why
have
you are
made them part.
restraining? Who is appearing for private respondent?
I am for the private respondent, madam.
Yes,
My lord,
why?
there is a civil suit preferred by the petitioner before the learned court below, my lord. The petitioner applied for new electricity connection in the year 2018.
Where? In the civil suit?
No. He applied for electricity connection in the year 2018, my lord. An inspection was conducted in my absence, insofar as my instruction is there, my lord. They are saying that the two poles will be erected for providing electricity connection to the house of the petitioner, my lord. I don't have any objection, but the fact remains, my lord, they are trying to take the high tension wire from the rooftop.
Can't be high tension. Electricity supply for domestic purposes can't be high
My lord,
tension. The house will be blown.
The wire they are trying, I stand corrected, my lord. The wire they are trying to take, my lord, from the rooftop of my house.
Yes,
If
why
they will
you
provide
don't have an alternative way? Why rooftop of somebody's house?
My lord, take instruction. This is my instruction. Objection raised the private respondent.
That is there. But why don't you find out an alternative way? You conduct an inspection in presence of both the parties and find out an alternative way. The petitioner alleges
Item number 11, I am for the petitioner lordship. Mr. Pothik Banerjee is appearing for CSC. He has personally requested me to take not today only.
Not
for
today.
lordship.
Next.
Well.
I'm for the petitioner, my lord.
I'm for the financial institution, Lordship. I'm for the
This-
bank.
This is affidavit service I'm
Column
submitting.
number 2 and 3, yes, Bank Limited.
Yes. What is your grievance?
Grievance. I'm telling you, it's a serious case that despite I have paid excess amount of their dues, they have taken over my positions, ousted me from the house. I came to the High Court because that time my directive one was not there. The High Court, Honorable High Court passed directions on the directive that it should be heard expeditiously and early. But that has not been taken up. By this time they put an auction sale. I filed a petition therein, but that day it was to be heard, and the day of auction sale, one of the landed advocate expired, and that's no resolution was there, could not be heard. By that time, they have sold the property. I am just drawing your kind attention on the page number 19 and 20.
Where is your application filed before the DRT?
That is there.
Where?
Last. Essay application is there.
It is pending there. Go and move the application there.
IA challenging the sale notice, the IA application challenging the sale notice is appearing at page 95, Lordship. The sale was conducted on 24th of July. It was successful and the sale certificate has already been issued in favor of the highest bid.
You challenge the sale notice, sale before the DRT.
Yes, I have already challenged all these things, but they are not taking up. But what is the remedy? Kindly
direct this DRT to consider it, to dispose that off. I will not be able to take it up if the essay is pending in any case.
No, kindly, in that case, that will be enough for me. For that, at least if it is, if the direction is given to them, they have given the date. Kindly see the 27th December, 17th December. Kindly.
Affidavit of service filed in court to
Yes.
Around 13, my lord,
For the CS, my lord.
I am appealing for the petitioner.
Petition, my lord, the direction was passed to serve the private respondents.
My lord, I have served. This is my affidavit of service.
Fact is that, my lord, it was an application for a new service line. We had been there, we have laid the pipeline, my lord, in an undemarcated plot. Then
Service is not complete.
Service is service, receipt
Delivered, yes.
delivered.
Then when we had been there to lay down the pipes, one Miss Sabina Yasmin came up, claimed herself to be one of the owners of the land, and my lord created objection for which the cable could not be laid. If your lordship so directs, my lord, we can go ahead with the work along with.
Who are you in respect of the property or the co-owner?
No, my lord, I am the developer and the co-owner. I am the co-owner and the developer.
And the line is crossing through a co-owned property.
No, my lord, that I cannot say, my lord, that the electric authority.
You have to say your property, you cannot say.
I have instruction that no line is crossing.
It doesn't appear that you have instructions because you are not sure.
Yes, my lord, I am sure.
Doesn't appear so.
Yeah, there is a sketch
If
map.
you cannot say, then you say you don't have
There
instructions.
is a sketch map through which we have laid down the pipe.
Sketch map where?
In my report. And we have laid it down through a plot of land, my lord, which is absolutely undemarcated till date.
Yes, in the sketch map where?
My lord, the blue portion, my lord, undemarcated
Blue
passage.
portion.
My lord.
Mine is all black.
Is it in blue? Common passage.
Yes.
Through which we have laid down the pipeline.
Yes, this is common passage.
And when we had been there to lay down the cable, we had been objected by one Sabina Yasmin, claiming herself to be one of the co-owners, and my lord, due to which the cable could not be laid. If your lordship kindly directs me, we will go ahead with police protection.
Likhen. Affidavit of service filed in court today is taken
petition in this matter. Connection attempted to be effected through my property, through the wall of my property, without my lord taking way leave. No way leave taken. Property, even the private respondent, my lord, has a different way through which the connection can be effected. But they have to take it, my lord, through my wall only. Now, this is some kind of a private dispute which is going on for a long time. But in somehow somebody is trying to gain some leverage over the other. But if I may just place the, I have objected. If I may place my objection.
The connection has been granted or not?
No,
yet?
not granted. My objection has stalled
Why
it
don't
for
you
some
find
time.
out an
And not one
alternative
more
way?
important.
So far, we have made all endeavor. Your letter has already been issued to the private respondent, though this writ petition has not been taken up by the private respondent. On that basis, we have found that only this is the way out through which we can draw the cable line. Now, on that basis, we are getting objection on that issue, and we made several on several occasions we have made an inspections, but we couldn't find out any alternative way. Neither the private respondent shown us any alternative way by which the cable can be drawn. And on that basis, we have given them a letter that if we do not get the alternative way or the wailing permission, you can take back the earnest money. This is the letter, and they have already received that.
You are appearing for the private
In
respondent.
this context, before your lordship transfer from me,
Have my deed in my name, and lordship, I have I do all the procedures whatever required to get the electric connection in the name of me. And lordship, it's not that his house just besides my house is not that. Between his house and my house, there is another house. They also having electric connection. And lordship, I have some photographs of the area. If your lordship kindly look into this.
they have a different passageway. They access the road through a different way.
No, road will not help. The electricity pole, the pole which has the transformer or whatever the source of electricity supply, from there the line has to go to the petitioner's house.
May I just
And
indicate,
that
but there
is
are other transformers, there are other ways as well. There is a different way as well. They have a different passage through which they access the road, and the electricity has to come from the pole through the
will
road.
not help if the passage is not near the source of the electricity supply. If the source is
Yes.
somewhere else, passage is somewhere else.
The transformer.
Passage you may take, but how will you take the line?
Not the transformer, if I may indicate, the transformer is there on the road, on the main road. Now the main road is accessed through a different passage. Now the electricity, there is no objection. They have their right of way through a different passage through which they can get the connection through. The cables can be laid through the way through which they access the road. But they has to, they are now seeking to take the electric connection only through my house, only to cartel price costs. It is through my house. The property is purchased in my name. I mean, residing there for 40 years, more than 40 years. Now they have a completely different way through which similar.
Wire is going to cross your property.
Across my property through my wall. Through my wall. I cannot access my roof.
This wall, lordship, these are the photographs if your lordship kindly see. And it's not that I am the only person who is asking for electric connection in this area, lordship, between his and
No,
my
you may
house.
not be the only person. You may not be the only person. You are entitled to electricity supply. There is no doubt about that.
And lordship,
But are you entitled to electricity supply by taking the wire through somebody's house is the question.
lordship, it's not that I want my electric connection through his wall only.
Then you show an alternative passage.
Yes.
You show an
Kindly see
alternative
my
passage
letter,
to
lordship.
them.
Kindly see the content
If you
of
are
the
able
letter.
to show an alternative way, then in that case they will do it. If you are none of you are able to show an alternative passage, then in that case the matter has to go before the district magistrate.
Because they have
For
received this
resolution.
letter till date, they haven't shown any alternative passage.
But they cannot even state.
Injunction against me.
Junction is neither here nor there, madam. You have to show an alternative passage without disturbing him. If you can take electricity, very well. If you want to take electricity through a passage which is causing disturbance to him, then the district magistrate will have to find out what the alternative way is.
Lordship, if any alternative way is required, then lordship, I only want my electric connection, whatever.
They have to find out. They have already. They don't even have to find out. They have a separate access point to the main road on which the transformer is lying. There is. I have stated. Your lordship kindly looks at paragraph. I have stated clearly.
Let them
Let
show
them in
an
affidavit.
alternative way which is technically feasible.
Which according to you is the alternative.
They
You
have
show it
their
to them.
access. The road they use.
Your oral saying will not do. You show them also the alternative way. You are
Already
stopping
I've said so. If your lordship kindly comes to paragraph, your lordship kindly takes a paragraph 13. I've indicated in my petition. They have said that it is
Your
also
petition
notable
will
here.
not do. Your petition and your submission are as good as on
But then I
paper.
can produce.
You have to show them if they go for inspection that this is the alternative
Yes,
way.
let
They
them
have
take
to
an
be
inspection. I shall
No, we
show
have made
physically.
on a several occasions we have.
I shall
You
indicate
conduct one
physically.
more inspection in presence
Yes.
of both the parties.
Yes.
If alternative way is found out, well and good.
Yes.
Otherwise, it will be
Subject
before
to
the DA.
technical feasibility, we are ready and willing to give that, but we are not getting that.
When can you have the inspection?
Any day, as your lordship desires. Any day, any time, my
Time
lord.
or date has been maybe fixed, Lordship.
I'm a retired person living at home only. I can, my lord, assist your lordship any day. Assist the authority.
আর ওনার এই ফটোগ্রাফ গুলো ওনাকে next.
Lordship, I am for the petition. Lordship, kindly sees the last order, Lordship. Lordship, petitioner is a tenant, Lordship, applied for a domestic connection. CSA authority filed a report and thereafter Lordship passed the last direction to ascertain whether the disconnected meter can be removed and a new meter in the name of the petitioner can be installed, Lordship.
Firstly, this is a Basti area, 60 square feet of accommodation. That is not, technically it's not possible. Now, my lord, he's already deriving supply from his neighbor's meter. And there is a disconnected meter which can be reconnected on compliances and additional payment. Only concern is, my lord, the dues of the past consumer is around 6,696. That, but because my lord, what happens is this is a Basti area, people come,
and
they
go.
take electricity, they go away,
Right.
and then the company
Lordship, I have to pay the other person's dues. Lordship, I am offering to pay 3,000. Let the connection be given, Lordship.
whatever due, we can reconnect.
How can you budget?
Lordship, then, Lordship, there is the regulation, Lordship. The other person's dues, I am not entitled to pay, Lordship.
We can give a fresh connection, we can reconnect the existing meter, all can be done, provided it pays the due, because otherwise this company is suffering great losses.
Lordship, there is the regulation 13.9, Lordship. Lordship, I am offering to pay 3,000, Lordship. Let the connection.
0.9 in respect of the same premises, pro rata.
Same premises, I have no nexus, Lordship.
Nexus is not required for new connection, same premises, sufficient.
Lordship, then Lordship kindly fixes tomorrow, Lordship, I will take instruction with the petitioner.
Not today.
And Lordship, new meter will be given upon payment of the.
That is all right, only the dues, my lord.
That's right, because in those premises, very difficult to find out who went, who came.
Lordship.
They take and then they leave.
Lordship, I will take instruction tomorrow, madam.
Grateful, your lordship.
I appear on behalf of the CAC in this matter.
And for the KMC lordship led by Mr. Gopal Chandra Das. Lordship, I'm praying for not today, your lordship.
The KMC was supposed to file a report, man. Let that report be.
She is also praying for time. Next.
Oh, lordship, I have the report.
What is the use? Next.
Roshan for the petition. So there's a direction to serve. I have served. Nilanjan Bhattacharya is appearing. I have served him. Nilanjan Bhattacharya senior.
What is this matter?
Your Lordship, this matter relates to, kindly turns to page number 16. The petitioner herein is the owner of a portion of the land situated at Khotian number 240. But your Lordship, the private respondent, being a financial company, they have issued a notice under section 13(4) of the Surface Act, your Lordship, thereafter over my property. But the schedule of that notice is not of my property, and I am never connected with that property. And moreover, the amount they have demanded from me, from the persons in the notice, that is not me. I have no way connected over that property. Kindly turns to page number 25, the typed copy of the notice, your Lordship. The schedule portion, your Lordship will find. Page number 24 is the actual notice, and page number 25 typed copy. Last two portion, your Lordship will find the schedule of the property. The first instance, I have shown your Lordship that I am the owner of Khotian number 240. And they are claiming, your Lordship, the Khotian number 10192 and Khotian number 390189 and 412. I have no way connected with that property, your Lordship. My simple prayer before the DM, I have made the representation that to remove the notice from my property. This is my simple prayer, let it be considered. My representations are there, 28, page number 28. Because the DM is the authorized officer, your Lordship, under Rule 8, your Lordship, because of this physical possession, your Lordship, because the notice has been given for physical possession. So it is the DM is the appropriate person who will consider my notice, and thereafter, your Lordship, let them take the action.
DM does not have adjudicatory power.
But your Lordship, the notice has been issued by the DM. Because until and unless
DM has given this notice.
Until and unless the
DM has issued the notice, answer the query.
Lordship.
Where has the DM
issued the notice? This matter relates to symbolic possession. They have taken the physical possession.
DM has no role to play here.
But your Lordship, subject to your Lordship's correction, your Lordship, the physical possession can be taken up only upon the order by the DM.
It can be taken up even without the order of the DM. There is no law that physical possession has to be taken only by the order of the DM.
I stand corrected.
Noble Kumar.
I stand corrected. But your Lordship, I have just made a representation. Let it be considered because
he has no authority. DM's role is just ministerial. If you want to challenge the action taken by the person concerned under Surface Act, then you have to approach the DRT.
Not against the surface, but they have issued the notice over my property. I am not connected to their property.
Yes, but the notice over your property under Surface Act only.
Yes, but I have no current. This matter
is assailable before the DRT. Yes. Yes, madam.
Lordship, I am knowing nothing in this matter at this present, Lordship, because I am led by senior standing Lordship. Lordship, I will go through the brief and leave cross over or fix for another date, Lordship.
Well, not today. Not today.
May I, man? But this is that matter where
I'm appearing for the licensing company.
I have challenged the 5 lakh compensation which has been granted in favor of me on the ground that my compensation should be higher up, my lord. I have lost my child. This was an abundant uh, wind project where a ladder had come down, and I have filed, I have affirmed a supplementary affidavit subject to leave it if it can be filed. I have taken the sum of rupees 5 lakhs without prejudice to my rights and contentions. I've taken that sum, but I'm challenging the quantum by way of this writ petition.
What will happen to the division bench?
Division bench, my lord, is there, my lord. I cannot run away from that part.
How will
But
the
there-
single bench get over that?
The only thing, there's a judgment of the Honorable High Court of Jammu and Kashmir.
That will not bind me. I will be bound by.
I bow down to your lordship that the division bench says that there's a policy by which 5 lakhs has been paid,
And that is all.
and that is all, man. That is what it says. But even in the state of Jammu Kashmir, that policy is also there.
That can be argued by you before the division bench, who would be competent to get across its own decision. Single bench cannot rely.
I bow down to your lord.
Overrule division bench.
I bow down to your lordship. The only thing the honorable division bench may not have.
Jammu Kashmir High Court will only have persuasive value.
Man, I bow down to it.
Binding for me.
And I bow down to your
Judgment of
lordship.
This court is binding on me.
I bow.
Get around it in any way, unless you show Supreme Court. If you show that yes, there is a Supreme Court precedent, then that is a different thing. I cannot get around division bench.
The only thing the honorable division bench may not have considered the judgment of the single bench. This is that I bow down to your lordship. I cannot improve what is there. But the only thing an honorable single bench is there which has recommended the multiplier principle. That judgment has not even been considered. Probably that judgment was not
Against
cited.
that judgment only there was division bench.
From that judgment there was a division bench, but in that particular division when that was by Honorable Justice Rajashekhar Mantha, my lord, there the order was stayed to the extent of the portion above 5 lakhs, and 5 lakhs was directed to be deposited.
Judgment of the then Chief Justice has stopped it at 5 lakh.
My lord, there is another judgment. This is my lord.
Very well, you file your supplementary, let them file their affidavits, we shall see.
May I file my
Supplementary affidavit filed in court today is taken. Not change any order. Yes.
Lord, I will request your lordship to take up item number 30 first, my lord. More or less, the four are same. 12, 30 is also fixed at 12, my lord.
Lordship 28 I am praying for pass over lordship that's কোনো অসুবিধা না কোনো
Mr. Kaur is leading me. I am there, my lord. Mr. Kaur will join.
All these matters are similar, same and except, my lord, item number 29. My lord, this has 29 has somehow, my lord.
No, 29 to 12 fix no.
हाँ ওটা ঢুকে গেছে হ্যাঁ
No, 28, 30, 31, 30.
আচ্ছা
ঠিক আছে
28 30 31 32 item number 30 টা দিয়ে 30 I appear for the
I'll request Manu will take up 30 first, Manu.
Yes, Mr. Siddiqui, I'm taking up 31st.
that kindly takes it because I am there in 30 only. I was led by Mr. Vikas Ranjan Bhattacharya is not there, my lord. I'll
দিদি এগুলো আপনি আমায় দিলেন আমি কি করে পড়বো সব একসঙ্গে এরকম সুতো ফুতে বাঁধা আমি পড়বো না তো
ট্যাব
আগে করে নেবেন দিদি এগুলো পড়তে অসুবিধা হবে প্রত্যেক দিন এই এক জিনিস Yes.
My lord, this is with regard to, my lord, tariff fixation, my lord. The lordship knows, my lord, that there are two areas of tariff fixation in the state of West Bengal. One is multi-licensing area, and other in the rest of the West Bengal is single licensing area. Now, there is in many areas there are multi-licensees which are operating like the DVC, WBSC, DCL, IPCL, my lord. And there is a single licensing area that is, for example, my lord, we in Kolkata we have a single licensee that is the CSC Limited. So, in multi-licensing area, that is specifically in our case, the Damodar Valley Corporation area, my lord, there is, well, for the multi-licensees, there is, my lord, a provision, a specific provision, which is section 62 of the Electricity Act. Lordship kindly takes up section 62 of the Electricity, because, my lord, I'm just giving you the gist of the matter. There are, my lord, so many papers exchanged. This is with regard to fixation of tariff.
62.
62. is determination of tariff.
Yes.
Well, the appropriate 62(1), the appropriate commission shall determine the tariff in accordance with the provision of this act for A, supply of electricity by a generating company to a distribution licensee, provided that the appropriate commission may, in case of shortage of supply of electricity, fix the minimum and maximum ceiling of tariff for sale or purchase of electricity in pursuance of an agreement entered into between a generating company and a licensee or between licensees for a period not exceeding 1 year to ensure reasonable prices of electricity. B is transmission of electricity. C is wheeling of electricity. D is retail sale of electricity. Then, my lord, provided is important. Provided that in case of distribution of electricity in the same area by two or more distribution licensees, the appropriate commission may, for promoting competition among distribution licensees, fix only maximum ceiling, not minimum, maximum ceiling of tariff for retail sale of electricity. Now, my lord, in the DVC command area, there are different players. I am a rice mill owner, my lord. I fall outside the DVC command area. Just outside the DVC command area. In the DVC command area, there are different players. Well, there is DVCL itself, that is WBSEDCL. Now they have, my lord, the maximum tariff is fixed, minimum can decrease, minimum can decrease for to provide to promote competition. Now what has happened in this DVC command area, the tariff has been reduced. Same nature of work, same consumption, bulk consumption of electricity, my lord, we are also doing in the DVC command area. The same work is being done by another rice mill owner. Same set of machineries, same production capacity. But the difficulty lies, since in DVC command area there are multiple licenses, and since they can lower the price, and since the parent statute provides that there can be competition, so they can do it. The law provides that. I'm not challenging that section 62(1). They have done it. Their prices are lowered because they are getting less tariff, the less rate provided by the DVC. And I have to pay the higher provided by the WBC SEDCL. And to the same WBC SEDCL, I have to pay the higher charges because that is not provided in our case. There is no multiple licensee. I am situated in a place where there is a single licensee. No matter I am affected. Because of this minimum, I am affected. I approach the Central Grievance Redressal Officer. Now, the Central Grievance Redressal Officer, my lord, turned down my prayer on the ground that he does not have the jurisdiction at page 93 of my rate petition.
Page 93.
93, my lord.
Yes.
Well, discriminatory tariff, the heading which has been given. If you cut lordship, my lord, to cut short matter, if your lordship kindly comes to the last paragraph. Further, this is to state that the tariff order is determined and published by WBERC. So in this regard, it is not possible to take any action from this end at CGRO level. Hence, your prayer is not considered. My lord, this jurisdiction he had, if your lordship kindly comes to page 81. This is the West Bengal, page 81. This is the West Bengal Electricity Regulatory Commission guidelines for establishment of forum for redressal of grievances of consumers and time and manner of dealing with such grievances by the Ombudsman Regulations 2013. Now, if your lordship kindly comes to page 83. I approach the GRO, Grievance Redressal Officer, page 83.
Yes.
Functions of the Grievance Redressal Officer. The functions of the Grievance Redressal Officer at the level of sub-districts, districts, regions, zone consist of receiving petitions from consumers stating their respective grievances, acknowledging them in writing, consulting superior technical experts if called for, holding spot inspections if considered necessary, and hearing the complaints, redressal of such grievances within a specific time limits as laid down in this set of regulations within the framework of Electricity Act 2023 and the rules and regulations made thereunder, passing reasoned and speaking order towards the aforesaid goal, stating clearly about redressal of grievance and awarding of compensation, if any, separately, communicating such orders to the petitioners, maintaining an account of grievance petitions received, disposed of, submission of reports, returning statistics as may be asked for by the corporate headquarters, any other. My lord, now the consumer grievance, my lord, if your lordship kindly turns back to page 82, the definition clause, regulation 2 III, consumer grievance means a grievance in an appropriate written form in accordance with these regulations by a consumer against a distribution licensee under the provision of this Electricity Act. He had that determination. Well, be that as it may, my lord, since he did not exercise his jurisdiction, I approached the Ombudsman. In spite of there being his jurisdiction to decide over the issue, did not do so. I oppose the ombudsman against such inaction at page 94.
Yes.
In connection with this application before the ombudsman, the West Bengal State Electricity Development Corporation Limited, that is the licensee, submitted its case in a one page at page 97. At page 97.
Page 94 is your complaint.
Page 94 is my complaint before the ombudsman.
Page 97.
94, my lord, I'll just trouble your lordship. 94, if your lordship kindly looks at the penultimate paragraph. Has your lordship got that one? I'm sorry, I'm taking. This discrimination in power tariff is not only impeding the financial viability of our business, but also unduly favoring similarly circumstanced competition which have been enjoying benefits of the discontinued tariff. It will be in the fitness of things if the applicant can also be allowed to avail of the discounted tariff. Now, my lord, if your lordship in the same page, look at the chart, my lord. I have made a chart. The existing tariff is 695, and in DVC command area, it comes around 478. The difference is 217. That is around more than 30 to 35%. 30 to 35%. Summer normal, monsoon normal, winter normal, summer peak, monsoon peak, winter peak, every period. 30 to 35%. And that liability is being passed on to me. That is the main crux of the matter. That liability, that loss which the WBSEDCL is suffering is being passed on to me. The law, my lord, bestows upon them to encourage competition in an area where there is multiple licensee. But that does not mean that they can, my lord, shrug off that liability, whatever loss they are incurring, they can pass on to me. That I will just demonstrate before your lordship. Now, my lord, if your lordship now comes to page 97, that is the contention of WBSEDCL. So, page 97. From serial number 1, the concerned petitioner is getting power supply at 11 kVA voltage, and the tariff category is under the WBERC tariff order dated 28th of February 2023. The petitioner approached before the learned so and so regarding discriminatory tariff on so and so, and the matter was intimated to the petitioner video letterman number so and so, the copy of the same. Further, this is to be mentioned that the tariff order is determined and published by WBERC. So they are only saying the tariff order is determined by WBERC. Our contention starts from page 99. We made an elaborate contention, my lord. Lord. My lord, I'll just trouble your lordship with the relevant paragraphs of our contention. But from serial number 6 at page 100. That to the utter shock and surprise of the appellant, it came to the knowledge of the appellant that WBSEDCL, being a state instrumentality, based on its notification dated so and so, 8 May 2017 and 28th February 2023, has been charging at different rates of tariff for retail sale of electricity to its similar consumers in the DVC command area, which has been substantially low, terming it to be a notified tariff than the tariff rate it is charging for its similar consumers in other parts of the state of West Bengal, which is grossly discriminatory, arbitrary, and against the basic principles of equity, justice, and good conscience. That on 28th July, WBERC issued its tariff order for the period 2020-21 21-22 and 22-23 in respect of WBSCDCL. The said tariff order of WBSCDCL is applicable across all the areas of the state of West Bengal to which it supplies power for different categories of consumer. It transpires that in the aforesaid tariff orders, the tariff rates have been increased in comparison to the tariff rates fixed for the previous control periods. However, shockingly, WBSCDCL has been charging the increased tariff to its consumers only in the areas apart from the DVC command area, where it has not even revised the previously fixed discounted tariff extended pursuant to the notification dated so and so. That the discounted tariff as notified by WBCDL for DVC command area is up to rupees 2.35 per kWh, kilowatt per hour, lower compared to its own regulated tariff imposed in other parts, and is almost 21% discount to the normal tariff charged by it in such other parts. That as a result of discounted tariff imposition for supply of power in the DVC command, many members of our association forced to pay around 21% higher input cost in terms of payment for monthly power consumption than the similarly situated industries, as they are being charged for power consumption by WBSCDCL at a discounted rate. Whereas some of the rice mills enjoying the discounted tariffs are being able to offer their goods in the command market at a price which is 15% lower. The other members of our association with such prohibitive higher input costs due to discriminatory tariff charged by WBCD are not being able to sell their products in the competitive market. My business is virtually going to be closed due to such cutthroat discriminatory pricing of electricity, which is the primary input for any production. The same businesses situated in areas other than in DVC command area being increasingly unable to sustain their business. Such act is so and so, my lord, the enjoined terms. Thus, by allowing two distinct power tariffs for similar industries, WBSCDCL is perhaps creating economic differentiation on the basis of location through market and other operational factors. Is perhaps creating economic, have you also got that, my lord? Differentiation on the basis of location through market and other operational factors remain the same for all the rice mills across the state of West Bengal. The appellant has requested for a fixation of low tariffs. Article 14 violation, we said. Constitution of the constitutional discrimination, we said. Well, this we have said. If your lordship kindly comes to page 103, third line from the top, the loss suffered by the WBSCDCL by offering discounted rate of tariff in the DVC command area is being compensated by changing higher rate of tariff in its monopoly area, which is adversely affecting the appellant and creating a discrimination. Now, my lord, the ombudsman passed the impugned order, which is at page 114. There are, my lord, prior to that, there are interim orders and all. 114 is the final order, which was passed on 3rd of December 2024. The complainant had approached this forum regarding discrimination of tariff for their 11 kV power supply at the above location. The complainant company approached the learned CGRO on 10th November 2023, who passed an order on 22nd November 2023. Not being satisfied with the order, the complainant company has approached this forum for redressal of their grievances. On asking a factual report, the licensee has submitted a report with a memo number so-and-so, report number so-and-so, which is considered as part of the OP. The case is accordingly taken up in presence of the following so-and-so. At the outset, both the parties submitted the respective arguments. It appears from the terms of second interim order dated so-and-so, AP has submitted his views in the instant case with a letter dated so-and-so, which is considered and kept on record. At the outset, both the parties submitted the respective organs. On the basis of submission of both the parties, it is held that AP has prayed for extension of tariff benefits, which is enjoyed by the industrial units even to the non-DVC command area. The provision of giving tariff benefits to the industrial units of DVC command area is being done as per the provision of WBERC. Hence, this issue of extension of the tariff benefit even to the non-command area of DVC is beyond the scope of settlement of this forum. Therefore, since there is no other grievance to adjudicate, it felt that the case is to be finalized without issuing any draft settlement order. The case is thus disposed of. without giving any direction to both the parties. So in terms of clause 10.5, final order is issued that the case is thus disposed of without giving any direction to both the parties, that the case is thus finally disposed of. Lord, nothing. No mention with regard to discrimination. No mention with regard to the burden being shifted upon me.
He has not decided. He said
Nothing,
it
nothing
has
has been decided. Nothing has been decided. Nothing has been decided. না মানে দ্যাট ইজ টাইপ রেগুলেশন। এটা কোন পাতায় ছিল ওটা প্রতিদিন বলেছিল ট্যারিফ রেগুলেশন, ঠিক আছে। দিস ইজ দি West Bengal Electricity Regulatory Commission Terms and Conditions of Tariff Regulations 2011 এটা দিয়ে দিতে। Well, Lordship may kindly turns to the page number, my lord, is hidden with this stitch. 2.2.2. It is only after 8 or 10 pages. 2.2.2. At the it's possibly page number 16. 16.
Yes.
If your lordship sees 2.2.2, I'll just place it, my lord. In addition, the commission may also keep in view and be guided by the requirements relating to the compliance of environmental standards to reduce the health risks of, my lord, not one. I'm not disturbing your lordship with one. There are several. My lordship may kindly turns to 16 and the next page, the last one.
Yes.
Requirement to meet the accounting standards applicable to a generating company or a licensee as per law, provided that while determining the tariff, the commission may keep in view the existing and future balances available under consumer account, tariff and dividend control account, undistributed rebates, development reserve, contingency reserve, deferred taxation reserve, along with its investment and income in accordance with regulation 5.4.1 of these regulations, provided further that the commission, depending upon the available factors, data, information, or any other material which it may consider appropriate in each case, may either fix separate rates or by any other method impose extra charges, incentives, penalty, etc. on the basic tariff to achieve purpose of any or more factors mentioned above to the extent feasible, and keeping in view the overall interest of the consumers, licensees, generating company, and of the electrical system as a whole. Provided also that the tariffs of any licensee determined under these regulations for different categories of consumers are the maximum ceilings for supply of electricity at any agreed price to the consumers only for those areas of supplies of the licensee where multiple licenses exist, subject to the condition, you lordship may kindly mark that, subject to the condition that if for effecting of supply of electricity to any consumer at such lesser price than the above mentioned upper ceiling, the licensee incurs any loss, such loss shall not be allowed to be passed on to any other consumers or any other licensee of the commission. Now, my lord, what has happened in our case? My lord, we have taken out a supplementary affidavit. Your lordship may kindly takes our supplementary affidavit. It's a voluminous supplementary affidavit. What ache didi okhane?
Yes.
This supplementary affidavit there is a performance review appraisal of the
Yes.
There is a performance review appraisal of 2022-23, which starts from page 6 of the supplementary affidavit. Order of the, it is, my lord, titled as Order of the West Bengal Electricity Regulatory Commission in case number so and so in regard, has your lordship got, my lord, page 6, I'm sorry, my lord. In regard to the application submitted by WBSEDCL for approval of fuel and power purchase, cost adjustment, and annual performance review for financial year 2022-23. But I'll not say it's an elaborate document, my lord, because this is a performance appraisal report, all these orders. If your lordship kindly comes to page 55 of the supplementary affidavit, that is internal page 49 of this order.
Page 55.
Page 55. The commission observed, my lord, starting from the top, my lord. 55, sir. Ponchon. Running page? No. Supplementary page, supplementary affidavit page. Lord, the my lord, starts from 4.21.3.4. The commission observed that WBSEDCL during the tariff petition for the 7th control period proposed the consumer tariff considering the sale of power to consumers of its license area, including the sale of power in the multiple license area. In the tariff order for 2022-23, the commission has determined the tariff considering the total sale of power to consumers of WBSEDCL, including the multiple license area. The commission observes that the contention of WBSEDCL as mentioned at paragraph 4.21.3.3 above to bill the consumers in the multiple license area, that is the contention of WBSEDCL, in the multiple license area on the basis to cover the marginal cost of supply will result to passing of entire burden of fixed cost to other consumers of WBSEDCL. Thus, the methodology of billing in the competitive license area adopted by WBSEDCL tantamount to passing of loss to other consumers of WBSEDCL, which is not in line with the third proviso of regulation 2.2.2 of that, which I just read, my lord, 2.2. Now, my lord, if your lordship looks at the chart, that table 29, sale in multiple license area, sale at 33 kV, so much and so, sale at 132 kV, so and so, subtotal is so and so. Then, my lord, T&D loss, loss in distribution, loss in STU system. Lordship may kindly comes to the last column, G, gain loss on account of sale of power to consumers in multiple license area is in lakhs, my lord. It is in lakhs. It is 0, 10, 100. 371 crores, 50 lakhs. That is being passed on to this consumer. And this, my lord, I tender my apology. We have only annexed for the period 2022-23. The same report is there for 2023 and 24 also. What are the annexes? 23-24? বললি না সেম জিনিসটা আছে এটা তো আমার আছে তুই তো দিস নি কিছু তোর এই ভালো ডাইজেস্ট তোর ব্রিফলি এখানে না না ট্যারিফ
This is for 22-23.
This is 22-23. It is same, my lord. We'll try to get it, my lord. Now, my lord, there are so many papers before your lordship. My lord, huge pleadings, supplementary affidavit. The entire case is based on these facts only. And the entire case, subject to correction by my learned senior friends, is of the respondents are based upon the judgment passed by this honorable court in the case of Rajadhiraj Tirupani Vinayak Natraj Private Limited, which is reported in 2024 SCC Online, Calcutta 4252.
2000?
24, you had a judgment.
SCC online
Because this particular case has decided upon whether there can be discriminatory tariff or not. I also say, my lord, that I am not challenging the virus of section 62, the proviso to section 62. So there can be discriminatory tariff for encouraging competition. No doubt about that. But while discriminating on tariff, while encouraging competition, you cannot pass on the buck to other consumers. You have to shoulder the responsibility. My case is centered upon this. And this fact,
what was the citation? 2024 SCC online Cal?
Cal 4252. My lord, we have, my lord, somehow.
There is an unreported judgment on record. Yes, it's there. 25028 WPA 25028.
Radha Dhiraj Tirupati Vinayak Nataraj. My lord, Justice Shobhachaji Bhattacharya's judgment. Now, my lord, if your lordship kindly looks at that judgment, my lord, we have. I am not asking your lordship to take a different view from that judgment. What I am on today, my lord.
Yes, I understood that while discriminatory tariff is permissible,
right,
the effect of the discriminatory tariff should not be passed on to you.
Right. My lord, that has been specifically stated in that particular judgment also, which is in my favor.
Page?
Lord, because I have an SCC online copy.
Reported on.
কোন প্যারাগ্রাফ ছিল রে? খোল তুই আইপ্যাডটা খোল। My lord, if your lordship kindly comes from this paragraph, my lord, which also supports the respondent's case. But in my SCC online copy, it is paragraph 44, the premise of section 62(1). Then
yes, it is same.
The premise of section 62(1) provisos that the statute makes an exception for multi-licensee areas where, in order to promote fair competition, extend the benefit of such competition to consumers, only a maximum civil limit of tariff is fixed. The licensees operating in such areas do not have the liberty to exceed such maximum limit, but in order to compete with each other, may very well cut their prices, of course, with approval of the commission. As opposed to such areas in a single licensee, there is no option for competing as a single operator distributor. Hence, in such areas, the commission has to fix specific tariff. But I also, my lord, I do not say that your lordship take a contrary view to this. The other arguments, my lord, paragraph 46. The other argument made by the petitioner is that the loss suffered by WBSCDCL in multi-licensee areas is shifted to consumers of command areas where WBSCDCL operates solely. However, such argument is also belied by clause 2.2.2, 16th third proviso of the tariff regulations framed by WBERC. Such proviso clearly stipulates that in case of multi-licensee areas where there is a maximum selling tariff, a licensee cannot pass on a competitive tariff loss to other consumers. Thus, the very apprehension of the petitioner is misplaced, as in terms of the said proviso, the WBSCDCL is debarred from passing on its losses in multi-licensee command areas to consumers in single licensee command areas, such as the petitioner. Well, this fact with regard to this passing of the burden in 2022-23, then again in 2020-24 was not there before my Lord Justice Bhattacharya. That burden has in fact passed upon us.
Yes.
My Lord, today the law has been settled. Yes, they can do. And I also say, the statute provides, the parent statute provides. But I also say, but that discrimination has led to I bearing the loss. You cannot pass the burden, shift the burden to me. Lord, this is my, because I am not, my lord, this is my entire case. The recent, my lord, that appraisal performance report, my lord, my learned friend, my lord, Mr. They will just hand it over to you. So, corporate on the আরেকটা performance appraisal report আছে স্যার
নেক্সট ইয়ারের পারফরম্যান্সটাও নিয়ে এসো আর কি।
Lord, these are well, short and simple submissions before.
Yes, Mr. Kaur.
But may I take the lordship's leave, my lord?
Yes,
Mr. Day is here.
The case made in the writ petition and case made out in the supplementary affidavit are two different cases. So I take it that my learned friend is giving up his case made in the writ petition and Lord is trying to Lord develop his case based on the supplementary affidavit.
In the writ petition,
In the writ petition, Lord, this passing of loss case is not made out. Subject to correction, I'll take your lordship through the grounds. Kindly, my lord, come to the grounds of the writ petition, starts at paragraph 55, page, my lord, 19. Your lordships will find the entire case is based on Article 14.
Page 90.
Page 19. 19, Lord, grounds, Lord, your lordships kindly come to page paragraph 55. This is, Lord,
paragraph
55, 555. Lord, your lordship is looking at, Lord, this Durga Mata, paragraph 55.
55
Grounds?
Grounds, yes.
Your lordship has found that. Kindly see the grounds, Lord. This is all based on Article 14, that on the basis of geographical location of the industry, one cannot discriminate. Article 14. This is the very case, Lord, that was dealt with in that Rajadhiraj judgment.
But in this Rajadhiraj judgment, the constitutionality of the tariff was also challenged. The regulation was also challenged.
Yes, it was.
That was challenged.
And Lord, considering Lord a Supreme Court judgment, the learned judge held that
The
constitutionality.
tariff is not challenging the tariff here.
Now, Lord, only Lord the passing of a burden. I am not being technical. I'll Lord answer my learned friend's point, but I just wanted to point out that Lord, he is giving up his case made in the writ petition, and Lord, he is trying to develop his case on the basis of the supplementary affidavit, of which I will answer. Which I'll answer. There is not a single grounds taken on the basis of passing of burden to the other consumers. Ground 14, your lordships will find that 30% lower rate, etc. All these points are taken. But no, these are all anvil of different locations, multiple licensee area, single license area. The industry is being situated in different locations. And Lord, there is no averment or grounds that, Lord, this is being passed on to the other consumers. Now, Lord, may I just briefly, sorry.
No, paragraph ground 19, Mr.
Kindly come to ground 19. Arbitrary discount
is thereafter
to industrial consumers.
It is recovering from
Similarly placed industrial consumers carrying on the same business situated outside DVC command area by charging a higher tariff. This is on Article 14.
No, this also is in a sense passing on the loss, because once you are recovering it, you are passing on the loss. That is
Lord,
what it means.
What the whole writ petition proceeds on the basis that because there are two different tariffs which are fixed, one for the DVC command area, which is a multiple license area, and one for the single license area, then the discounted price is being recovered. The loss is being passed on. His case in
discounted price actually translates into the loss only, because if I give a discount to you, then in that case I am suffering a loss in the sense that I am not charging the same price to some other person who, according to him, you would also have been charged at a higher rate. You are being charged at a lower rate. So the higher rate which I am charging from the other person is to compensate myself to the extent I have charged lower from you. That is what it means. That is what I have understood.
Lord, ground 19, my humble reading of ground 19 is that, Lord, I am charging a lower rate in DVC command area, and I am charging a higher rate in the single licensee area.
So you are recovering your loss from me.
No, he is saying, if I may just recovering from, it says command area by incurring a loss which it is recovering from similarly placed industrial consumer. The discounted price which I am offering to the DVC command area, I am suffering a loss which I am recovering from them.
So that is passing over the loss to them.
Now, Lord, this is vis-a-vis his ground he had taken on the in the writ petition, saying that the two different tariffs is not permissible. This is violative of Article 14. The definite ground.
But in the representation also that he has made before the authority, which he just took me through.
Yes.
There also this passing of the loss factor is there.
Lord, let us not get into this nicety of things. As I said, I am not being technical. I will answer that point also. Now, Lord, let me first ask this question to myself: is it permissible in law in a multiple license area to make it more competitive? Is it permissible in law?
That it is.
It is.
That has been answered by the
Section 62 read with the notification.
And has been answered by the coordinate bench in specific
Now,
terms.
Your Lordship, kindly in this regard, takes Lord 2011 regulation once. Look, that clause 2.2 16.
Clause 2.2.2.16.
Kindly, Lord, come to 2.2.2. Lord, one thing, I don't fix the tariff. WB SCDCL do not fix the tariff. The tariff is fixed by the Electricity Regulatory Commission. Now, Lord, reading section 62, read with the regulation, kindly, Lord, have a look at regulation 16. It says, requirement to meet the accounting standards. Lord, 2.2, kindly come to 16. Requirement to meet accounting standards applicable to a generating company or a licensee as per law. So it is accounting standard. What is to be done? Kindly come to the second proviso. Provided further, the Commission, depending upon the available factors, data, information, or any other material which it may consider appropriate in each case, may either fix separate rates or by any other method impose extra charges, incentives, penalty, etc. on the basic tariff to achieve the purpose of any one or more factors mentioned above, to the extent feasible and keeping in view the overall interest of the consumers, licensees, generating company, and on the electrical system as a whole. Now, your Lordships, kindly come to the next proviso. Provided also that the tariffs of any licensee determined under these regulations for different categories of consumer under the maximum ceiling for supply of electricity at any agreed price to the consumers only for those areas of supply of the licensee where multiple licensees exist, subject to the condition that if for effecting supply of electricity to any consumer at such lesser price than the above mentioned upper ceiling, the licensee incurs any loss, such loss shall not be allowed to be passed on to any other consumer or any other licensees of the commission. Now, Lord, kindly consider this, that WBSEDCL supplies Lord electricity to the DVC area and also Lord non-DVC area. Now, Lord, for DVC area, the Regulatory Commission has fixed a maximum tariff. Because if your Lordship looks at section 62, my Lord will find that, Lord, what is permitted, fixing of only maximum ceiling of tariff. Your Lordships may kindly see section 62. So, my Lord, how much you may go down, the loss will occur only when I don't recover the operation cost also. It is not my profit. It is recovery of the operational cost. Lord, if I operate, Lord, in any area, be it DVC, be non-DVC, first I'll have to recover, Lord, my operational cost. Then the question of profit comes. So, Lord, when we think about the parameters under 62 and fixing of the maximum price is applicable for the non-DVC area, because that is the price I have to sell. I cannot reduce that price. Only for the purpose of competition under 62, this is permissible for the purpose of promotion of supply of electricity and to encourage competition between the two electricity companies. Whatever price I sell, DVC is also selling at that price. It's not that DVC is selling at a higher price. Wherever we are competing, we are selling at the same price. So, Lord, the profit that I am making in other areas can't be applicable so far as the DVC area is concerned. There is no loss sustained by SEDCL which is being passed on to the consumer, because we are recovering the operational cost. Your Lordships may kindly, in this regard, take the that supplementary affidavit once. I am only not concentrating on the passing off of loss, because Lord, the other point is
the only question now.
That's the only question. Now, Lord, your Lordships may kindly come to page 54 of this supplementary affidavit.
Lord, I'm just reading. One thing I must want to. Mr. Kaur is the privileged person because he can argue for both sides. He's a brilliant man. We also know what. No.
Seems to be a bad day for me.
No.
Can I seek an adjournment?
No. So, my Lord, unfortunately, in my matter,
he's arguing for the other side.
No, he didn't oblige with a copy of. He didn't file any affidavit, which is very relevant in my matter.
কোন ম্যাটারটা তোমার দাদা?
আমাদের নাম্বার
আমরা ভয় পেয়ে ফাইল করিনি। তোমার
28.
28.
No affidavit. I have not been obliged with a copy of the affidavit because he say he took a plea. So for other petitioners concerned, in their case it was done. But how is it?
তুমি কি বলছো যে অ্যাফিডেভিট দিতে?
তুমি দাওনি আর দেওয়ার প্রশ্ন আসে না because you are trying to here to me 28? No, my dear, you have not given. So how can I?
নম্বরটা একটু দেবেন দিদি? একটু দেখুন affidavit.
Sorry to interrupt, my lord. I'm extremely sorry.
না, সরিটা কিসের?
28.
সরিটা কেন?
আমাকে কোনো কপি দেয়নি অ্যাফিডেভিটের। আপনি দেখুন।
ফাইল করেছো তো?
ফাইল করেছে, আমাকে কপি দাও।
দিয়েছি।
দাও দেখো।
Affidavit in opposition.
সব কটা দিয়েছে। Do you want I must swear an affidavit? I can do that. My client. No copy of the affidavit, sir. In national supplementary affidavit.
We have filed, my lord, probably.
বোধহয় ভুল হচ্ছে একটু
হতে
বোধহয়
পারে
ভুল-
হতে পারে
একটু বোধহয় ভুল হচ্ছে
Affidavit in opposition on behalf of WBSCDCL is there.
Yes. I think the WBERC has not.
I think 28 the years. That was the other matters we used to.
Yes, Electricity Regulatory Commission has not.
তোমায় বলছেন in general
এত প্রিভিলেজ টিভিলেজ বলছো
Matters all of
the supplementary affidavit which you have used against that no affidavit by Mr. Korta.
Supplementary affidavit you have only brought on record.
But the loss is concerned, my lord.
But we have already filed a reply to the supplementary affidavit in the other matters. এটাতে ফাইল করেছো?
না, এটা তো opposition দিয়েছে।
অপোজিশনের পর সাপ্লিমেন্টারি
I have not been obliged.
I have filed in the other matters. My stand is the same. And in fact, the stand will appear from this order of the Electricity Regulatory Commission itself. That is my stand. But if my learned friend wants, Lord, I can just take a week's time and file, Lord, an affidavit treating.
Why don't you file the affidavits? Unnecessarily, these technical points will come. You file your affidavit, complete it. What is stopping you from?
Otherwise, I'll take a Supreme Court judgment. I'll cite no Supreme Court judgment, my lord. Which is straight away go against them.
আমাদের খালি
তো ওইটা ফাইল করোনি কেন? যখন ফাইল করেছো সব কটাতে ফাইল করেছো, একটাতে ফাইল করোনি কেন?
supplementary.
But
File it and
give us a
complete it,
week's
please.
time, Lord. We'll file same affidavit. It will be there.
Same কি
It should have been pointed out, Lord, at the beginning.
আমি আসতে পারিনি ভাই, আমায় ক্ষমা করে
Much obliged. I'm really sorry. PDB কেন দিব? ভুলে গেছে।
পাসওয়ার্ড করে দিতে পারবেন, এখন হয়তো কেউ থাকবে না।
My lord, I am appearing for the licensing company.
My lord, I am appearing for the private respondent, my lord. As per your lordship's last order, my lord, I have been impleaded to the writ petition.
Not there. Passover next.
Kuri.
My lord, kindly not today, my lord.
Right, they might come.
19 Q.
Or suddenly the bench has broken, they may not know.
Passover.
Next.
Wait.
I'm for the petitioner.
You are there.
As no, only 19 I was. As per your lordship's order, your lordship, the CSC has visited my client's space and they have handed over me a report. Lordship, but
He is appearing for CSC.
he was here, your lordship.
Passing it over.
Lordship, kindly make it not to do.
For 23 lordship, I appear for WPCTCL. The direction was there, my lord, to submit one report.
I am for the state, my lord.
23 petition, they passed over. Next.
Possible, lords.
24 lordship, I am for the petition.
CSC.
24 lordship, I am for the petition.
Yes, I.
On the last occasion, there was a direction to make inspection of the premises.
Actually, the bench has suddenly, the matter was suddenly stopped. That is why maybe people may.
Matter was?
The matter which was ongoing abruptly stopped.
The fixed matter,
So people may not be knowing. I'm passing it over.
Lordship.
I'm for the petition. On the last occasion, Mr.
Okay.
Sahara,
For possible lordship, I am praying.
Sahara appeared.
24 has come.
24.
Not possible lordship, he will come.
I'm sorry.
24, Vishwajit, 22. CSC is here.
22 or 24? I'm sorry, not.
I understand because the suddenly abruptly the matter. Yes.
May I submit the report? Sorry. My lord, the inspection was conducted on 3rd August in presence of both the parties. It transpired, my lord, the petitioner is residing, my lord, around 100 meters from the main road, and the private respondents are residing at the back portion of the said premises. Now, my lord, they are co-sharers, and my lord, deriving supply from a common meter box position. Now, my lord, where there are two live meters. Now, my lord, the meter of the petitioner is live, but not connected to internal wiring due to objection raised by the private respondents. So, my lord, this is the position. What we suggest, my lord, if your lordship so desires, my lord, an order may be passed, my lord, a date may be fixed in the presence of the police officers. Our men will be there. They will disconnect the meter for the time being. In the meantime, the petitioner will connect and complete the internal wiring so that the supply can be provided at his residence. This can be done, my lord. Otherwise, my lord, as far as our steps are concerned, my lord, we have no role to play. Because, my lord, they are co-sharers. 2 meters are in a private meter box position, which is being supplied from a common service line.
Shifting was paid only because of that. The wiring was, they were not allowing me to draw the wire from the meter. That is why I have made a representation for shifting of the meter to my premise.
Not possible.
No, my lord, because my lord, same premises, structurally not separate, and my lord, 2 meters are there. So, 2 separate, my lord, service connection, my lord, it will not be feasible. It will be risky, my lord. My lord, we can, my lord, be there.
Private respondent. He was
No,
represented
no.
on the last occasion.
He was here at morning.
He has to be there because police protection or police assistance in his absence, it will not be possible. Since he was represented, it is not a case of him not coming.
He will not be the affected party.
Yes,
He is
your
the
lord.
person who is raising objection
That is
and
why he
has affixed a padlock
You
in
are
the
appealing
main
for the
meter.
private respondent.
22 আপনি আছেন?
No, no. My lord, 19 my application.
22টা হচ্ছে, 22টা হচ্ছে ধরেন।
Not the way.
This is the position, my lord. Private respondent was there, my lord.
I'm making it day after tomorrow. You let him come.
My lord.
Due to my diabetic problem, I had
24টা column.
Both parties
24 column.
are not taken.
my lord, other side is here, my lord.
He is not the other side. Petitioner has to be there.
মানে ওখানে আমাদের একটা জায়গা তো
24টা column হবে?
20, my lord, item 20.
24 এও আছি আমরা।
24
20.
21
20.
20.
20 column.
And on the last occasion, pursuant to the report filed by the company, my lord, and pursuant to lordship's direction, we have added the private respondents. And as per the report, the connection.
My lord, I am appearing for the private respondents, my lord. My lord, my contention is that the petitioner has described himself as the occupier of the dark number. My lord, he has no iota of right title interest or even the possession, my lord. My lord, he only has forged one deed and got his name recorded in the LR record of rights. And that is why it is pending challenge. The record is pending challenge before the competent authority, my lord. And kindly sees, my lord, we are the, my lord, recorded owners as well as the riots and the owners of the dark, my
Have
lord.
you conducted inspection and found them in possession?
Yes, my lord, we are.
He only has one porcha in his name.
Yes, my lord.
Possession আছে আমরা? Possession এ আছে কিনা জিজ্ঞেস করছি Josh. Are we in possession?
Have you conducted inspection and found out whether he is in possession or not?
We are taking the connection. Yes, my lord.
Please conduct an inspection, file a report whether he is in possession or not.
Yes, ma'am.
However, my instruction is we are in possession and we are also the co-owners. He's disputing it.
Found in possession, then in that case, his objection will go.
And Lordship kindly sees the report filed by the company on the last occasion. We were found present when the inspection was done and we have signed it also. Monomar Khan. Lordship kindly sees the first LTI.
My lord, as per my instruction, my lord.
The instruction is incorrect, my lord. With
Deed
respect, I
as well as the record, my lord.
That is, whether it is forged or not is.
That will be decided later on.
That is subject matter of us.
That will not strike them out of the possession if they are in possession. If physically they are in possession.
Physically, no, my lord. As per my instruction, they are not.
Conduct an inspection specifically, they will bring this on record.
Grateful to your Lordship.
My lord, may I be permitted to mention one, my lord?
Show the judgment
Said that he did not find any judgment.
regarding
Impounding.
impound. The বই দুটো দাম দেখিয়ে দিচ্ছি।
Impounding I will not touch, but so
Then,
far
my
as
lord,
addition of party is concerned,
addition of party, my lord, 2 or 3 things, my lord. My erstwhile leader had already submitted to your lordship, my lord, the 2 things, my lord, 23 3A, my lord, order 23 rule 1, my lord, that is 1.
even if it is not order 23 rule 1, the conduct of the petitioner when he says, once he says he had knowledge, then he says he got knowledge later on, this belies because it's a rule of public policy. And
Lord,
this appears to be more with the intent to delay.
Public policy, my lord, will only 11.5, my lord, will only appear when it was, my lord, my lord, decided.
You see,
It was, my lord, subject to correction.
Sarguja transport, even in cases of writ petition, it was said that it is not the rule of res judicata. It is the rule of public policy that you cannot come over and over again.
Now, that is there, my lord, 1, my lord,
Sarguja transport was in respect of writ petition.
Writ petition.
Where the Supreme Court said that this rule should be extended even to writ petitions because it undermines public policy.
This is, my lord, that is, my lord, the whole point, my lord. This is, my lord, interlocutory application 1. Secondly,
Interlocutory application, the conduct of the petitioner belies this because it again undermines public policy. He had knowledge at that point of time. He chose not to pursue. Now, in an execution case, it can be seen by the court as an attempt to put spanner in the wheels of the execution case. That should not be allowed.
And my lord, number 2, my lord, it's, my lord, the plaintiff, my lord, here the petitioner, my lord, he is in the capacity of dominus litis. He can add, my lord, in the capacity order 1 rule.
It is not the plaintiff's application. It is not the petitioner's
No,
application.
this is, my lord, in a miscase, my lord, deemed to be a plaintiff.
In the miscase,
Deemed to
he
be
is
a
not the
plaintiff.
misapplicant.
He
is not the misapplicant. It is not the misapplicant's application for adding him. So therefore,
therefore the applicants are not challenging that.
Maybe
The applicants are not challenging that.
They have not the persons
At least-
who want to be added have not been able.
At least the degree holder has no locus standi to challenge this.
Decree holder has, because decree holder's execution is being stalled because of this. It is not that you could have segregated these 2 proceedings. If you could have said that the execution case and the miscase have no connection altogether at all, but the execution case is being stalled because of the miscase. Therefore, there is a connection. And in any case, whatever the result of miscase is, will have direct bearing on the execution case.
Exactly so. Exactly so. That is the therefore execution cannot be proceeded with. Well, this is exactly the point.
Therefore, the decree holder has the right to object, and
Very
he has
well.
rightly objected.
Right.
And therefore,
And the object should fail. And the object should fail. This is exactly the point. I am grateful to your lordship. This is a direct bearing. Otherwise, my lord, the language, kindly see the language of order 21 rule 99 100 101.
Point of yours has already been scotched in the earlier round before the same court, where this court has said that the court, even at the execution stage, will apply the Aribandhanam and see that if it is a grossly non-maintainable miscase which has been filed, it will not proceed with it, and the execution will not be stalled merely because a miscellaneous case has been filed 30 days, 30 years after some deed having been surfaced.
Lord,
Therefore,
judgment,
on that ground alone, it has already been.
Lord, that judgment, my lord, subject to correction, have not taken into consideration when there is an execution case, interlocutory application pending in an execution case.
I will deal with that.
Milord, that judgment I have read, Milord, that is not the Milord subject.
Judgment.
Milord, Peruammal, which Milord, my Lord has read.
Periamal is a different case. The earlier round of revisional application has relied on this T. Arivandandan's case.
That is for stay.
Yes.
The stay, Milord, has not been granted. My Lord has already dismissed the stay
So
application.
stay has not been granted and the execution will be stalled till such time the miscase will go. There cannot be a deemed stay, Mr. Bhattacharya.
So then, Milord,
There
kindly
cannot be a
see,
deemed
Milord,
stay.
when should I, Milord, apply before the executing
You
court?
should have applied when you got the deed. 89 deed you will apply in 2025. Seek stay of an execution of a decree of 1982.
Kindly, Milord, very well. 89 execution case, Milord. It is, Milord, when, Milord, the point when I am being dispossessed. Milord, that is the language of Order 21, Rule 99, 100, 101.
You may have been dispossessed at that point of time. What is your right? You have to show that you have a right. You have to show that you have a right. What kind of right does the deed give to you? If you go that deep, how would you deal with Section 54 of the Transfer of Property
Milord,
Act? It's just an agreement. You don't have a right. What kind of a right do you have? That the more we go deep, the more problematic it will become.
My Lord is saying about 54
of the TP Act. Agreement for sale does not create any right in the property. It does not create any interest in the property. What interest do you have? You only have possession. So therefore, that does not mean that merely because of that deed of 1988 you will be allowed to stop
I'm
the
entitled to
execution
Milord
case.
confirmation of possession.
Not now. Not now.
Permission of possession, because the agreement
You have filed a suit for specific performance,
True,
which may be
true,
barred now.
True. No, that is not barred because limitation, exactly so. Limitation, Milord, Article 54 has two parts.
Then in under 141 you will get restitution. Even
Under-
if you are dispossessed.
Well,
If
why
you
should
have such a good case?
One-
Let the execution proceed. You will get.
Well, 144, Milord, Milord, I should not, cannot wait for that stage.
You should not. You could not have waited for that stage if you are a bit prompt and you were reasonable in timing. Your case does not show confidence. Does not inspire confidence of the court. Your case does not inspire confidence of your own client. The person who was a signatory, he seeks to be added 1 year later. So therefore, there are several lines in the way.
This is what, Milord, I cannot.
Very well. He can ensure.
for the official liquidator. My lord, it's my application for resolution of the company in liquidation. Now, my lord, if your lordship kindly remember, after going through my affidavit, your lordship was pleased to grant me leave to file a supplementary affidavit giving some details. Now, this is the supplementary affidavit.
No, the affidavit, it was yet to be filed. Affidavit has not been filed as yet.
No, my lord, yes, my lord, this is the affidavit, my lord. Now, my lord, if your lordships kindly see the paragraph 2 of the supplementary affidavit, my lord, the no records, nothing is with the office of the official liquidator. My lord, paragraph 2, my lord, I have stated so. Only thing, my lord, the property which was put up for sale, that sale was conducted, and my lord, a sum of rupees 3 lakhs and odd. That is also mentioned in paragraph 4. And now that amount is lying as 7,67,265. Well, no invitation was done because of the claim cannot be, my lord, at that point of time, the claim was not invited. It was 20 years, more than the 20 years. Yes, yes. My lord, paragraph 2 and 3, my lord, and my lord, no proceeding is pending. Paragraph 2, it is mentioned, no proceedings is pending as of now. And that amount also.
You have said why this supplementary affidavit is being filed, but you
Yes.
have not said that no proceeding is pending. Where
No,
you
my lord,
said-
kindly see the paragraph 2, last 2 paragraph, as well as, my lord, indicate as to whether there are any
This is
proceedings.
because of the order.
Yes.
You are referring to the order.
Then, my
dated
lord, kindly see paragraph 3.
Paragraph 3 also does not say that.
My lord, kindly is paragraph 6. It is mentioned, my lord. My lord, in that view of the matter, my lord, I am seeking, my lord, your lordship's order, my lord, as per the mention of the summons, my lord, prayer D, E, and F. My lord, may I, my lord, assist your lordship, my lord? This is an order. No, we have makes several prayers, but my lord, since the amount is very, so this, my lord, your lordship, if you yes, and an amount, my lord, I have sought for that amount should be transferred to the Reserve Bank of India under section 555. My lord, that has also mentioned in the, my lord, the prayer. My lord, prayer E that mentioned, and prayer F, my lord, the books and papers, dispose of books and papers.
Yes. What about B?
Yes, my lord, I am also asking for D.
B.
Oh, B, my lord, because if I ask for prayer B, then, my lord, I have to again explain. It will take time, and, my lord, there is no record. So the possibility, my lord, the accounts I cannot, my lord, they are audited because the records are not there.
Very well. लिखे नहीं.
Hey, please, my lord, I appeal for the official liquidator in the matter. My lord, the earlier occasion the matter was taken up, your lordship had, my lord, directed that an affidavit be filed with regards to how, my lord, the workers were taken care of. My lord, may I be allowed, permitted to file, my lord, the affidavits, my lord. One is the competency and the other is, my lord, the affidavit. By this application, my lord, I am seeking dissolution. My lord, there is nothing, my lord, pending as on date, my lord. There is nothing pending.
Para number 13, my lord.
Paragraph number 13.
Thir-
এটা নয়, ওটা অন্য কথা। এটার পরে নেই। ইয়েতে রেখে চলে এসেছি সকালবেলায়। My lord, the present fund position is, my lord, 1,46,478. My lord, that is of my main application. Will appear from, my lord, paragraph 17 at page 6. My lord, that's not this affidavit, that's the main application. Records and books, my lord, are not available as I've been told. Not many, my lord, some are available. Not all records are available.
Sufficient funds are also not there, my lord.
Sufficient funds, my lord, are not there. 1,47,000, my lord, is
And books
pretty
and
meager.
records, for so many years, no.
No, no. Okay. Yes. My lord, it's paragraph 18, my lord. That's a dispensation, my lord. My lord, that's the only paragraph that's there, my lord.
Books and records available. If my lord can direct, will.
No, no, paragraph
But-
3 te dewa
but my
ache.
lord,
Not all are available.
Meager amount, so how can?
I beg your pardon, my lord?
What? One
My
lakh,
lord,
1,50,000, yes, 1,50,000.
Now, your lordship, my lord,
It is also 85 CP, 1980.
my lord, if I may draw your lordship's attention, my lord, to a similar order. However, there, my lord, the books and records were not there. However, my lord, it has been passed on commercial imprudence, my lord. This is by his lordship, Lord Justice Kapoor. My lord, there's one paragraph, my lord. So, whether your lordship, my lord, base it on the on the prudence, considering. My lord, if your lordship so, my lord, wants, we'll, my lord, put in an account audit, my lord. There's nobody standing, my lord. But considering the meager amount that is there, if your lordship so wants, my lord, lock, stock, and barrel, everything, my lord, will be placed before the Reserve Bank, my lord, like how it has happened. My lord, the affidavit, my lord.
My lord, this is my company application. My lord, this matter, this is the affidavit of service. This matter, my prayer is to implead West Bengal Industrial Infrastructure Development Corporation as a party to the proceedings. The reason is, my lord, this is a property land which belongs to WBIIDC. WBIIDC had given it on lease 99 years to the company which is in liquidation. Now thereafter, the matter proceeded, BIFR case was initiated and it was proceeding in this honorable court. Auction took place. In the auction, we were the successful purchasers. We paid the official liquidator 5.5 crores. We paid WBIIDC another 3 crores. And thereafter, we developed that property and our factory is running there. We have invested already about 15 to 20 crores in that property. Now, 23 crores. 23 crores in that property. Property is about 24 acres in near about Kharagpur. In that situation, Lordship's coordinate bench directed the matter to transfer it to NCLT, assailing which one of the creditor filed an appeal. We also got ourselves impleaded in the appeal. Lordship straightaway comes to that order at page 17, 17. I'm giving little conspectus of the matter. That's why. This is the Lordship's coordinate bench's order. Transferred the matter to Company Law Tribunal, Kolkata. Assailing which the appeal was preferred. Lordship kindly sees the final order in the appeal at page 22. Kindly sees the first line. The purchaser of the Kharagpur unit of the company, Measure such and such, seeks leave of this court to participate in these proceedings by filing application SEO 3. That was our application in the appeal. Now, I am the purchaser. I am the purchaser. Now, Lordship kindly comes to bottom of page 23, next page. I'm not reading the rest portion, only direction. Hence, in the interest of all stakeholders and in the interest of justice, the winding up proceedings should be continued and concluded. Yes. And next page, all points raised by the Kharagpur unit purchaser before us are kept open before the learned single judge. After that, before this honorable court, we proceeded, we exchanged our deeds. The deeds have been finalized with the will. Now the deeds are required to be executed. But since the property belongs to WBIIDC, they are a confirming party to this agreement. And they said that if we are made a party, we will participate and give consent. That's why we require Lordship's consent to be implemented. I don't think will have.
Bengal can be treated as a party. So in this application, your Lordship, prayer
Not State of West Bengal, WBIIDC.
prayer A and prayer B can only be allowed, your Lordship. At this point of time.
Yes, after that, C will come to provide necessary assistance. That's obviously after that.
Wait, please, my lord, I pick it. My lord, similar, my lord, as my lord, the second matter, my lord, so far as books and records, dispensation has been sought for. My lord, averment, whether there are books and records, is not there. My lord, if your lordship, my lord, passes a similar direction, or my lord, your lordship takes it up. Fund position, I'll tell you, lordship, my lord, is 1,63,000, my lord. 1,61,000. My lord, that's at page 6, paragraph 10 of my affidavit. Please, my lord, I appear for the official liquidator. My lord, will kindly consider first, my lord, my report. I'll tell your lordship why. My lord, this company went. Company went into liquidation sometime in, my lord, 1992. Now, Lord, what has happened there after the official liquidator, my lord, has taken possession of the assets and properties. Now, after the assets have been taken, my lord, possession of, one of the assets, my lord, was in Rajasthan. Now, my lord, the Rajasthan property was put up for sale on a valuation being made. Initially, the valuation which was made, my lord, was at around 36 lakhs odd. Now, my lord, for orders of the Honorable Court, my lord, we put up advertisement and, my lord, the reserve price was kept at 36 lakhs. My lord, during the sale was, my lord, conducted by, my lord, e-auction. At the time of e-auction, my lord, the intending purchasers, my lord, the bid went up to, my lord, somewhat around 2 crores. Now, my lord, they have to put in their earnest money deposits. The earnest money deposit is with us. Now, my lord, so far as confirmation of the sale is concerned, my lord, that, my lord, is yet to happen. Now, Lord, in the meantime, Lord, lands of one of the particular land which was subject matter of the e-auction was, my lord, sold by one of the erstwhile directors of the company. My lord, it was sold by one of the erstwhile directors of the company to a person called, my lord, Motilal. Now, Lord, this Motilal, my lord, apparently sold to 2 other people. My lord, they are applicants before, my lord, your lordship today in, my lord, CA number 54. CA number 54. My lord, here, my lord, they, my lord, seek to intervene. CA 53, my lord, is my application. Now, my lord, the sale which, my lord, I'll tell you. My lord, CA 54 was filed on the premise that the sale that was made by way of a registered deed. My lord, this deed having, my lord, been executed in 2011. Now, my lord, the company goes into liquidation in 1992. My lord, thereafter possession taken. Now, my lord, we come to know that the Rajasthan property, my lord, somehow were encumbered. My lord, we started writing to, my lord, the revenue departments, my lord, for Rajasthan. My lord, property, my lord, proceedings were drawn up, and my lord, on the proceedings being drawn up, my lord, there were orders by way of which certain sales in respect of these properties in Rajasthan was done away with. My lord, the Tehsildar and, my lord, the revenue collector, my lord, they passed an order, my lord, completing the proceedings, saying that all other sales are bad in law. My lord, there's an order of closure to that effect, but then that order, however, is not before your lordship today because it was missed out. Apart from that, my lord, there were, my lord, records before the Tehsildar. My lord, I am told, my lord, these records are before the CDL. My lord, by the DLC, the district level committee. My lord, before the committee, the records, my lord, appear, in the records, the names appear as in the name of Motilal. My lord, the same person who, my lord, fraudulently, my lord, transferred this to the 2 other applicants which are before your lordship. Now, my lord, those records, my lord, also require being changed. And, my lord, if your lordship takes my summons for direction, For 53, my lord, not for 54. 54 is, my lord, the other side's application. I don't suppose they're represented. Now for 53, your lordship will see my prayer is leave may be granted to the official liquidator to serve a copy of the application concerned Tehsildar, Tehsil Mandal, village Adu, district Bhilwara. Well, this was, my lord, given. My lord, leave, the prayer B is leave may be granted to the official liquidator to appoint an impanel valuer. My lord, this was also done. Fresh valuation was also done. Now, my lord, prayer C, D, and E is what I am before your lordship today for. My lord, direction be made upon the concerned Tehsildar to engage a patwari to demarcate the entire plots of landed assets comparing with Mauja plan, and my lord, rename the plots of the landed assets in the name of the company, because my lord, of that place where the Tehsil records Motilal as. So these are the prayers before your lordship today by way of 53. As far as 54 is concerned, my lord, I'll say this application, my lord, requires being dismissed. I'll tell your lordship why. Again, my lord, the company goes into liquidation in 92. In, my lord, 2010, my lord, the director, the erstwhile director, while, my lord, subsistence of these liquidation proceedings, he, my lord, makes the sale. My lord, Motilal sells it in 2011. My lord, they themselves have, my lord, come up before your lordship and, my lord, said this to your lordship, my lord, saying that on the premise that the people who purchase the properties, my lord, they're praying, my lord, in 54 for, my lord, leave to intervene. 5 and 6, my lord. The premise of that application is one, my lord, is a dispute, a civil dispute, which is taken, my lord, the nature of a, my lord, suit. My lord, before. As your lordship pleases, my lord. As your lordship pleases, my lord. My lord. Same contract.
Yes, my lord. These are the applications by the ex-workman whose claim has been admitted by the official liquidator. Yes, the report, my lord, the report says that the claim may be disbursed, my lord.
Yes, Lordship,
Entirety of the claim.
I am appearing for the official. Yes, Lordship, one or two things I must indicate. Official liquidator. First of all, apologies, Lordship. Last day I could not appear before. If Lordship may take up annexure F in the report at page 20. First of all, page 21, the last two entry, 10 and 11 in page 21.
They are the applicants of
They are the applicant. They are the ex-workmen applicants of item number 7 and 8. There is a admitted claim of both around 40 lakhs and odds, and nothing is so far disbursed. But the first 1 to 9, the entries in 1 to 9 are workmen were claimant in a connected appeal, whereby an order dated 9th June of 2025, Honorable Division Bench has directed to disburse a portion of those 9 individuals' claim. We have done that. Lordship, in paragraph number 17 at page 8, we have stated the present fund condition of the official liquidator in this matter. The proposal from the official liquidator is if the balance portion of those 9 individuals' admitted claim could be disbursed as well along with these 2 applicants' entire claim.
But what I understand, my lord, the applicants that I was the advocate on record of those applicants also. That appeal court order I have annexed in my application, that is at page 16.
It is also annexed in the report.
Annexed in the report.
At page 17.
Page 17. Very well. In this matter, my lord, there were total 9 applicants. 9 applicants who came for disbursement, paying for disbursement of their admitted claims. In that, what has happened, the official liquidator filed a report. That report was made a part of the order. Kindly see page 18, that the next page, at the bottom portion. That was the report filed by the official liquidator, whereby they have said that I have made the calculation for better understanding and proper adjudication of the claims of the appellants herein. Present fund status was given, and the claims admitted by the official liquidator. There was an intercorporate lender claim. There was another party whose claim was there. Now, at present, that claim they have already got the money. Now, that is the submission of the official liquidator, that they will better.
So, pardon?
No, McLeod Russell. Pay gache bolo.
Yes, my lord. Acha. At page 8 of the report. At page 7 of the report, one secured creditor was McLeod Russell. The amount was paid fully.
Yes.
On 16th April 24. And on entry 3, 9 numbers of the ex-employees were paid a portion of their admitted claim on 9th June 2025.
No, partly. Only 9 applicants came. 58 did not come.
58 numbers of ex-employees also have been paid full. Paid in full. In terms of 2 orders. And order
50% was first given.
50% was first given. Yes, my lord. Yes. Yes. Partly paid so far. Yes, total 11.
That partly paid 9 applicants. I was the advocate on record, and that appeal that I had shown. That in that order, there was a direction that out of the admitted claims, 17.067% of the admitted claim will be disbursed to me. That was disbursed. 10 lakhs and odd were disbursed to the 9 applicants. Is that I can
That was a proposal from the official liquidator.
I can always direct that in terms of the report, the official liquidator can disburse the same to the
fund
applicants.
permits, the current
The
fund
funds
situation
permit
permits.
disbursal.
That's why that was a proposal.
Total amount to be disbursed to 9 plus 2.
The official liquidator can act in accord. Yes.
Yes, my lord.
In the report,
17 in the report. Last para, my lord.
At page 8, last portion.
Eight last portion. Therefore, the total amount to be disbursed rupees 5,61,058. Since the fund is adequate to mitigate the entire claims of 11 number of, including these two number of as applicants.
But the official liquidator can always act independently. Yes.
No, where?
Say, subject to correction, since there was an earlier order to
Yes.
to make payment of part of that admitted claim.
But if my lord sees the appeal court's order, the appeal court does not restrict disbursal. My lord, kindly see the order. But I am not representing them as of today, right now. But I am only seeking that if my lord directs the official liquidator to pay the remaining applicants, very good. Then my lord would kindly direct the disbursal of according to the applicants herein, the 10 and 11.
Applicants,
That may be
entire
given
admitted
in
claim they
entirety.
can disburse.
That is 4 lakhs and odd, my lord. That may be given in entirety. In the table that they have annexed, the item number 10 and 11 is the applicant herein. That would come around 4 lakhs.
65,000 and odds.
4,65,021 rupees. That may be disbursed to me.
Yes, my lord. Yes. My lord, they have not approached yet. The liquidation order was of 2008.
That market claim is first we have to pay. That is why.
Yes. But
their claim will come next.
No, there was only one secured creditor that has been paid.
They are not secured.
Your Lordship, my petition, Your Lordship, my 340 CRPC petition, Your Lordship. Your Lordship, may I file my affidavit of service, Your Lordship? Your Lordship, on last occasion, Your Lordship was of the view whether this petition is maintainable or not. But Your Lordship, coordinate bench was of the opinion that whether this petition is not maintainable. But Your Lordship, kindly see page number. Page number 21 once. Your Lordship, this is a rejoinder filed by the respondents before Your Lordship Company Court, Your Lordship, where Your Lordship, they have specifically pleaded at page 29. Lordship, 8th line. The purported shares transfer form are forged, manufactured, and have been brought into existence for the purpose of instant litigation. None of the applicant has received any consideration for the purported transfer. The signature shown is to be appearing in the purported transfer deed are not of any of the applicant. Significantly, the purported share certificate do not tally with the share folio number given in last annual return of company available with the ROC. Again, the purported share certificate do not contain the signature of the authorized signatory in any of them. Over here, they have alleged that I have forged and manufactured the document before Your Lordship before Your Lordship court. But Your Lordship kindly comes to page number 96 once. Lordship, this is a suit which they have filed before Your Lordship Honorable High Court at Bombay, where Your Lordship, they have specifically stated that this share certificate was transferred by them to the petitioner. Your Lordship, this suit in Bombay High Court was filed. Your Lordship, the pleading are there in Your Lordship. Your Lordship, I was not the party to this suit, Your Lordship. I was the party. No, I was not the party to. But Your Lordship, we were the party, Your Lordship. On instruction, I am submitting this. We were the party, but Your Lordship, we did not appear in this suit. Your Lordship, we were party to this suit. Your Lordship, over here, they are specifically saying page 96. Page 96, Your Lordship. Paragraph Roman H. Sometimes in 1999, Mr. Kerr, defendant number 1 herein, met the Mr. Sain. Mr. Sain, Your Lordship, they have described who is Mr. Sain in just paragraph G, Your Lordship. Misrepresented and that he already deposited rupees 1 crore with Punjab National Bank to liquidate the outstanding liability of Basanti unit, while no such amount was actually deposited by him. In good faith, trusting his word, Mr. Sain hand over to him the share certificate. Hand over to him, Your Lordship. Kindly see the language, Your Lordship. Hand over him to the share certificate with blank transfer forms duly signed by the promoter director of common seal of the company. But Your Lordship, I'm just, Your Lordship, since there is no the litigation, Your Lordship. But Your Lordship, kindly see, Your Lordship, thereafter we went to Supreme Court, Your Lordship. The litigation was pending all the while. Your Lordship, we got to know about this document. Your Lordship. Your Lordship. Your Lordship. But Your Lordship is well aware there is no limitation period as such under section 340. Your Lordship, there has to be. In the application, explanation about what, Your Lordship? Your Lordship, the explanation. No, Your Lordship. Lordship, I sent, subject to correction, Your Lordship. Subject to correction, Your Lordship. I can show from section 340. Your Lordship, this affidavit was affirmed before Your Lordship. That is why I am before Your Lordship. On affidavit, they are of. Your Lordship. But there is no denial, Your Lordship. There is specific allegation which they are making, Your Lordship, on affidavit and saying that I have fabricated and manufactured a document. Lordship, I'll come back. I'll consider those judgment and come back, Your Lordship. I'll just in the meanwhile, Your Lordship, my affidavit of service may be accepted, Your Lordship. ठीक है वो बात नहीं वो सब सुप्रीम कोर्ट का बात ही नहीं है I'm grateful, Your Lordship. नाम दे रही
My application for disclaimer. Last time also it had been.
Your Lordship, I appear for the official liquidator in the matter.
My Lord, kindly permit my learned junior to address your Lordship, my Lord. He wants to have the pleasure of addressing your Lordship for the first time.
No. My learned senior is very kind, Milord. This is my application for disclaimer of a property, Milord. May I just hand over a list of dates? I've prepared a list of dates for the convenience of this court, Milord. It's my application seeking disclaimer of a property, Milords, which was let out, Milords, under a leave and license agreement to the company in liquidation in the year 2006. Milords, the leave and license agreement is dated 15th May 2006. Now, Milords, under this leave and license agreement, the company in liquidation continued in possession till November 2010, Milords. Milords, I'll indicate from the list of dates also, Milords. In the year 2010, Milords, in the year 2010, particularly December 2010, another leave and license was entered between the parties for another period of 11 months. When this period expired, in November 2011, by a letter dated of November 2011, the company in liquidation sought for 1 month's extension, 2 months extension, to vacate and hand over peaceful possession to us. 1 month extension was given by us, but by another letter of 15 December 2011, we requested the company in liquidation to hand over possession because, we were not able to provide the 1 month extension. They did not hand over or give us the possession, despite categorically admitting in the letter that they would hand us possession. Thereafter, by an order dated 13th June 2013, which is at page 3 of the list of dates, the first item, the company in liquidation, the company was directed to be wound up by an order of this court, of this honorable court. Now, by a letter dated 15th July, which is the next item at page 3, at 15 July 2016, we saw a disclaimer from the official liquidator, which was not replied to. In those circumstances, the present application was filed before this honorable court. Now, after a long hiatus of 6 years, the matter was taken up by a coordinate bench of this honorable court, where an order was passed on 18th July 2023, may I just hand over a copy of that order to your lordships? Hey, copy. (2023). May I hand over a copy? Your lordships have it. In this 18 July 2023. Now, very interestingly, at the penultimate para of the first page, my learned senior friend's submission has been recorded. Today at the hearing, Mr. Bose, senior advocate appearing on behalf of applicant submits, the official liquidator had agreed to disclaim the premises on the condition that all the movable assets lying at the premises be removed at the cost and expense of the applicant. Mrs. Day who was representing the official liquidator at that point of time, appearing on behalf of official liquidator, does not oppose such submission. However, my lords, if your lordship will turn the page, my lords, the official liquidator reneged from this stand. However, the official liquidator present in person vehemently opposes the submission and clarifies that he has no such instructions to disclaim as has been submitted by the advocate, my lords. Now, my lords, thereafter, my lords, another order was passed by this by a coordinate bench of this honorable court, my lords, that is dated 28th August 2023, my lords. Now, my lords, in that order, my lords, the official liquidator changed its stand. Now they started to contend, my lords, that since the original lessee from which, my lords, I had acquired the land in question under a sublease was not a party to the application, so therefore the liquidation should not proceed on the premise, because there was a clause in the sublease which did not allow me to sublet without obtaining leave from the original lessee, my lords. So, my lords, therefore, my lords, may kindly take the order dated 28th August 2023, my lords, at page 2, my lords. This coordinate bench of this honorable court was pleased to direct the original lessee to be impleaded as a party, my lords. And that, my lords, may kindly take page 2. Pursuant to order dated, official liquidator is now represented in person and has taken a preliminary objection that the alleged owner of the premises, Commola Center Private Limited, who is also the original lessee of the subject premises, is not a party to the proceeding. Now, my lords, the penultimate paragraph of that order, my lords, or that page, in view of the peculiar circumstances of this case, the applicant as well as the official liquidator is directed to serve notice on Commola Law Center having its registered office at such and such. Now, my lords, the notices were served. Now, my lords, after the notices were served, Commola Law Center, my lords, filed an affidavit, my lords, on 22nd November 2023. My lords, that affidavit is on record, my lords. My lords, if I may just indicate from the affidavit. The affidavit has been filed on 22/11/23 by Advocate Nikunj Barlia. Because the affidavit is a little relevant, my lords. We kindly just take paragraph 5, my lords, of the affidavit at page 4, my lords. May I just place it for your lordship's kind consideration? Pursuant to the decree dated February 7, 1983, passed by Honorable High Court at Calcutta in suit 96 of 82, lesser being Shotacharan law, was directed to execute and register a deed of lease in favor of the lessee being the applicant herein. The decree also provided that in case of default of the lesser to execute and register a deed of lease, the learned registrar, original side High Court at Calcutta, was directed to execute and register deed of lease. Since the lesser declined, paragraph 6, to execute the lease in terms of the decree, the learned registrar, being Ms. Sudhamoy Mitra, registrar, original side High Court at Calcutta, had executed and registered the deed of lease dated March 29, 1983. All the above facts will be evident from a bare reading of the recital in the said deed of lease itself. The said lease was for a period of 99 years as indicated at page 5 of the lease deed, with an option of renewal for the period of 25 years. The salami has been noted. Now, paragraph 8. The said lease deed also contained a recital at internal page 2 of that the lessee being the applicant herein shall be entitled at its own cost and expenses to erect, construct, complete a multi-storied building after demolition of the existing one. Now, paragraph 9. The applicant herein, being the lessee, had the right to demolish, erect multi-storied building on such property, and as it has done in terms of the lease. The applicant further had a right to sublet, demise, or assign the demise premises or any portion thereof, or any new building or new buildings to be constructed thereon, and to sell any portion of the building or buildings, or to create mortgage or charge on its leasehold interest and on the demise premises, or the building or buildings to be constructed thereon, without requiring to obtain any consent of the lesser in terms of clause 7 of the lease deed at internal page 7. The applicant, in terms of the said clauses contained in, has granted, now, my lords, I come into picture. The applicant here, in my lords, has granted sublease of all that share in unit of 5 on 5th floor, my lords, comprising of 3/5, with a further right to let out or part with the possession of the said unit only after prior information in writing to the lessee as per clause H appearing at internal page 11 of the sublease. The applicant herein has therefore demolished and constructed a new building on such premises, and thereafter has entered into a sublease agreement with the original applicants of the instant application with respect of the said property. As such, the applicant, my lords, paragraph 12, had subleased to the original applicant with a right to further sublet upon payment of rupees 13 for an unexpired term of lease of 99 years. So, my lords, the lessee had gotten the property for a period of 99 years with an option of renewal of 25 years. And, my lords, he had sublet the property in my favor for that entire period. Now, my lords, yes, this was admitted, my lords, by Commonwealth Law Center, my lords, from whom I had acquired the property. Now, my lords, they had also clarified that there is no requirement to take any permission, and they, in para 13, they also said, my lords, therefore the applicant, being the head lessee, is unconnected to the instant dispute and may be discharged. So, my lords, they did not claim any right whatsoever, and they said that these proceedings can proceed. Now, my lords, thereafter, after the filing of this affidavit, my lords, the official liquidator filed an application, which is item number 11 before your lordships, which is CA number 14 of 2025.
That is in respect of the separate.
No, my lords, I'll just indicate, my lords.
Because this is not the property of the it is a exclusive property of the company in liquidation, which is sought to be sold.
Yes.
And my application is for sale of those properties.
Yes. Now, my lords, may I just indicate? Now, my lords, in that application, they sought leave to sell properties of the company in liquidation.
Only 2 properties, not
Only
properties.
there were 5 properties mentioned in the application. They sought leave to sell 2 flats, my lords. Now, my lords, very significantly in that application, my lords, they did not, my lords, may I just point out the page number of the application, my lords? Yes, my lords. Page 4, if your lordships have, my lords, there's a list given by them. My lords, item 1 is my property. Now, my lords, your lordships will kindly see they have possession of movable assets in form of furniture and fixture lying at registered office. Now, my lords, they did not include the freehold land to be valued, my lords, in their valuation report, as they have included in item number 2. My lords, item number 2, lordships will see possession of 2 flats, movable assets, flats about 1200 square feet and 1600 square feet. My lords, page 4, my lords, paragraph 5, there's a chart at the bottom. My lords, of CA 14 of 2025, my lords. Yes, my lords, there's a chart if your lordship sees. My lords, item 1 is my property, my lords. They have not included the freehold land and flat for evaluation or valuation of the property, my lords. My lords, I'll show that. That is subsequently also there, my lords. They pleaded that also. Whereas, my lords, they wanted to sell item number 2. Now, my lords, while valuating item number 2, they also valued the movable properties which are lying at the property which I am seeking disclosure of. My lords, which your lordships will find at paragraph 16, my lords. Well, first, your lordships will find at paragraph 12 at page 7 that Mr. Basudev De, valuer, submitted 2 price valuation report in respect of movable assets, that is furniture fixture lying at 156A Lenin Sarani, and 2 flats and movable assets situated at Mauja, Podra, Havra, as mentioned in this, and also submitted unpriced valuation in respect of the property. So, they did not want to sell my immovable property. They only valued the movable assets. Now, yes, now paragraph 16 at page 9, Malods, they also recorded that an application is pending seeking disclaimer of this property. And Malods, in 17, which is at page 10, Malods, they categorically recorded that, stated rather, that official liquidator High Court Calcutta is of the view that e-auction in respect of immovable properties, that is 2 flats in Havra, along with office furnished fixture at 156A to be initiated on the basis of the valuation report for ultimate benefit of the depositor. So, they didn't want to sell the property. When this application again came up for hearing before a coordinated bench of this honorable court, I had myself pointed out this fact to the honorable bench. Now, after noticing this, 2 orders were passed by this honorable court. One was dated 16th of April 2025. There also it has been recorded that my property has not been valued, the immovable property has not been valued, and only the movables have been valued. April, Justice Krishna Rao's order, may I just place it for your lordships? Paragraph 2, 16th April, 2025. Mr. Rono Chaudhary appears. The valuation report is open in court and found that the valuer has filed two valuation report, wherein in one valuation report, the fair market value of the property is shown as 7460. These are the flats. And the value of item available in the said property is shown as 8,700. Not this is now second valuation report is respect to the movables lying at the property, which I'm seeking disclaimer of. The valuer has stated that only movable properties, that is furniture and fixtures, are there, and the total cost of the said furniture and fixture is 46,050. 450. Now, by an order dated 18th June 2025, when we pointed out all these facts to the court directed us, this honorable court directed us, to take instruction as to whether we are willing to purchase the movables lying at the property which we are seeking disclaimer of. May kindly take the 18th June order, page 2, paragraph 8, 5, I'll just place first. Counsel for the applicant submits that another application being, which is the application which is being heard, is pending, and the same is to be listed before this court. Now, paragraph 8. In the meantime, counsel for the applicant is also directed to take instruction whether the applicant is ready to purchase the furniture and fixture available in the property in which the applicant is seeking disclaimer. Now, we are willing to take the movables. We are willing to pay the value, the price of the valuation report, which is 46,450. The property has become onerous. From December 2011 till the filing of the application, a sum of rupees 40 lakhs is due on account of rent, which has not been paid. Now, the company cannot use this property any further, because this honorable court has found that this company was involved in the business of Ponzi scheme. That is also recorded by an order of this honorable court dated 18th May 2023. That the company is a Ponzi scheme company, and there should not be any scheme for no scheme should be allowed for this in respect of this company or revival of this company. So therefore we are only praying that the property be disclaimed in our favor, because we had acquired the right through the sublease for the entire period of the for which it was leased out to the original lessee. So all rights, which are rights, liability, risks which are incidental to ownership, stood it was using the property as an office.
Your Lordship, I'm sorry, Your Lordship, I've not been able to hear Your Lordship, Your Lordship.
I'm sorry.
I just put it to him as to what was the interest that the company claimed in the property.
Nothing, the company doesn't claim any interest, they were just using it. In fact, by a letter.
There was no lease, nothing in favor of the company.
A leave and license agreement, there were two leave and license agreements, both for 11 months, The second,
the original lessee.
No, by us,
By you.
By us, in favor of the lessee. Now, yes.
The company was directed to be wound up when?
13th June 2013, That order is also there,
Your sublease was of what date?
I beg
your sublease was of what date? Is of what date?
My what is
your sublease? You are a sublease.
My sublease is of 28 January 1992. Long back, registered subleases. Now, the only legal point, which may come in between, subject to my limited understanding, is that, I had to seek leave from the original lessee to sublease to some other party. Now, that, in my respectful submission, will not apply to the facts of this case, because that proposition will be in teeth of Section 11 of Transfer of Property Act. May I just show your lordships the provision,
Perpetuity.
Perpetuity. Not perpetuity, may I just, maybe it is, I'll just hand over the section to your lordship. I extra copy. There is one. Last one. May I just place the section for your lordship's kind consideration, where on a transfer of a property, here there is a transfer, and interest therein is created absolutely in favor of any person. Interest has been created absolutely because the entire tenure of the lease has been subleased to me. The lease was for 99 years plus 25 years. That entire period has been given to me in the sublease, in favor of any person, but the terms of the transfer direct that such interest shall be applied or enjoyed by him in a particular manner, which is the case here that I had to take permission from the lessee, he shall be entitled to receive and dispose of such interest as if there was no such direction. Where any such direction has been made in respect of one piece of immovable property for the purpose of securing beneficial enjoyment, another piece, this is not our case, So, therefore, I am humbly submitting, that the property be disclaimed, and my learned senior friend.
Two sentences. But I have been there in the matter from the beginning. I tell your lordship, at various stages, I may be wrong, but from what I remember, my lord, both Kamalalaya, learned counsel, Mrs. Victoria, as also the official liquidator, strictly could not pinpoint any reason why they should not disclaim. Because the property has become inorious now. Either you disclaim the property or you pay some amount of occupation charges. Today, if you were to pay occupation charges, 40 lakhs would be due on payment. Strictly speaking, and I say this, my lord, from whatever I remember, both the official liquidator and the Kamalalaya council left it to court, my lord, to decide, because they cannot openly agree and say, yes, we are agreeable to give the property. Although it has been recorded in one of the orders which my learned junior has placed before your lordship, right? They were agreeable. But then I suppose, my lord, what happened internally, I don't know. I'm not even going into that. So strictly speaking, my lord, in law as also otherwise, my lord, perhaps the official liquidator has no other option but to return the property to me, my lord, to claim the property. Of course, as my learned junior has told your lordship, we are ready and willing to buy off the items which are lying there, my lord, depending on their valuation.
Yes, Miss Bhutoria.
Your lordship, what I was praying is, your lordship, if your lordship kindly keeps this matter on 26th, your lordship, of 26th August, your lordship, I'll come physically, because I'll indicate, your lordship, very clearly. The last I appeared in this matter was in 2025, your lordship. So when I came in the matter, your lordship, thereafter the instructions, or maybe I do not know, subsequently the instructions were to oppose this application. Now, your lordship, I need also instructions from the official liquidator, your lordship, before I proceed to make my submission. Because this matter appeared today, so I was instructed to appear, your lordship, by today morning, your lordship, actually. So I'll come back, your lordship, on 26th, your lordship will kindly fix the matter. I'll come and argue physically, your lordship. So whatever my instructions are, accordingly, I'll come and argue.
Your lordship has seen our stand, my lord.
Yes, yes.
If I may say so, we have tried to be
No,
as...
I have heard my learned friend. I'll take proper instructions and then only I'll come and address your lordship.
Something which is troubling me also, Miss Bhutoria, is this, that it can be said to be the asset of the company only if the company has title over the property. Now, the company is not a lessee, company is not a sub-lessee. If it is only a legal license agreement, then in that case, what right does the company have for the assets to be called the assets of the company in liquidation? Because this
I understand completely. I understand.
Company in liquidation if the company has some kind of interest, which is why my question to him was as to what interest does the company have. If the company doesn't have any interest, then in that case, merely because of it being an occupant, because leave by itself, leave and license will not create any right.
No.
License is something which would have been, but for the license, illegal. So the occupation also would have been illegal if there was...
I'll indicate, your lordship. Earlier, if your lordship will find, one of the orders was placed by my learned friend, wherein your lordships will find that the counsel who appeared, your lordship, for the liquidator had said no objection. But however, the liquidator objected.
Then even if we don't go to that, Miss Bhutoria, you have to demonstrate that the property is the property
of course,
of the
I will have
company
to.
Liquidation. Only then
of course,
can
I'll have to. No, I'm just making this point was that, your lordship, thereafter, your lordship, the honorable court, your lordship, because I was there in the court, had asked me to look into the matter and to see, because this was a chit fund company. So pursuant to that, I was briefed in the matter just to see as to what was there.
Hurdle will be required to be crossed. That
yes, absolutely.
Company will have to be shown. Some legal interest has to be there, which legal.
Yes, absolutely. Absolutely. Your lordship, can you give some time? I'll be there on 26th of August to argue this matter.
Yes. Heard Mr. Bose, learned senior advocate, appearing for the petitioner, assisted by Mr.
Ankan Rai,
Mr. Rai, learned advocate. Full stop.
26 may be a court holiday.
because of Eid.
No, but High Court is open on 26th.
So it's to be notified later. It may be 26th, 27th. Can we have it on 19th or?
Your Lordship will kindly give me a moment because I thought that's
have
a
some-
holiday and kindly give me a moment, Your Lordship. Kindly give me a moment.
Yes, you're right, because it all depends on the sighting.
Then keep it up. 26 September.
Then we can have it on 2nd September.
Very well. So deeply.
Second
Lordship, kindly give me a moment, Your Lordship. Kindly just give me a moment, Your Lordship. Can it be on 1st of September?
1st September is not a company matter day here in this court.
Very well.
It's-
2nd September? 2nd
September.
September. Very well. Very well.
As
I'll be there.
by Ms. Victoria, learned senior advocate appearing for the official liquidator, list this matter on 2nd September 2020. I'm very grateful.
So
I'm
deeply.
grateful.
So grateful for patient hearing.
Yes, my lord, that is in respect of the two flats.
Same day, because
My lord, my lord, this portion is not, my lord, they are agreeable. First of all, they are agreeable to purchase the
yes, but
mobile
that-
assets.
that will go with the other rider, whether you disclaim or not.
No, two flats are separate, my lord. Totally separate area. They have also not, also not raised any objection with regard to sale.
These two flats we are not concerned.
Yes, they are
in Havra.
If are concerned, then there will be no order. So far,
Yes, since they have agreed to purchase the, yes,
will go along with the disclaimer.
yes.
So the two flats.
Yes, only in respect of the two flats, my lord, my lord, I am submitting the valuation because I am seeking, my lord, the order for sale, my lord. My lord, if you lordships kindly see the summons. Yeah. My lord, prayer A. But first of all, your lordships kindly see the affidavit, my lord, page 4, item number 2. That is what I am seeking, my lord, for sale. Affidavit, my lord, page 4.
Yes, two flats.
Because yes, my lord, two flats. Because I have here, my lord, the description of the property which has been taken possession by the official liquidator, out of which item number 2 I am seeking for, my lord, prayer A, B, C. And my lord, that is the valuation report. Your lordships kindly fix the reserve price. Lord, possibly unpriced valuation has been annexed in this application, but the valuation report is price. This is the valuation report.
39,75,000.
Yes, my lord, your lordships kindly fix the reserve price and my lord pass in terms.
Order sheet gulo dekhi. Order sheet gulo dekhi. What was the valuation report that was submitted on 16th April 2025?
Then, my lord, the fresh valuation report was directed to be made. So that is the reason, my lord, fresh valuation report has been done.
No, but 16th April 2025, the valuation was 74,60,000.
Yes.
How has it gone down then? It has become 39,75,000.
Yes, my lord, that is the second valuation report. That is only in respect of the property, my lord, in respect of the two flats.
What was the valuation report that was submitted on 16th April? It was in
No, that must be in the on the record, my lord. That is in the record.
देखिए এই 16th April 2025 এ একটা ভ্যালুয়েশন রিপোর্ট ফাইল হয়েছিল সেটা কি এখানে নেই না
Because first sale was not, my lord, no bid was received. That is the reason for which second time valuation was done.
That has been mentioned in your application that the first, in respect of the
No,
first
that is
bid
in
was
the-
received.
With the publication. My lord, your lordship, kindly see the paper publication, my lord, which has been made previously.
দেখি ওইটা দিন তো।
এইটা দাও। এখানে দেয়। এখানে দেয়।
How can it be reduced to 39 almost, it goes almost half.
Yes, my lord, that is there, my lord. If your lordship, I can, my lord, your lordship, kindly direct the valuer to come and to satisfy your lordship that how this valuation can be done, reduced. So,
Who had done the earlier valuation?
or same person. But first was made by Basudev Rai and second was the Subhashish Mojumdar.
First was made by?
Vasudev Dey, sorry, Vasudev Dey. My lord, kindly turns to page 6 of the affidavit.
Page?
Page 6 of the affidavit.
Page 6 of the affidavit.
Yes.
Yes.
Then my lord, there was a direction because there was so many discrepancy in with regard to the land, Howrah land and so on. So that is not in respect of these two flats.
No, this auction sale, this is in valuation of 74 lakh. 68,000 is in value in respect of these two flats only because your advertisement shows that.
Yes, yes. Then, my lord, your lordship, kindly direct the valuer to appear before your lordship and to submit that how this.
Very well.
That would be better, my lord.
Valuation report filed in court today is taken.
For disclaimer. My lord, possibly the official liquidator is not opposing. I'll just indicate the facts. My lord, I think she is there, my lord. Yes, my lord. But in this matter, what happened was the company, one of the directors of the company was inducted as a tenant by my client's father. Now the company went into liquidation. On the winding up, my lord, the official liquidator went and came to take possession of the property. So, my lord, my father had filed an application for disclaimer. But I was not looking after the matter, my lord. The official liquidator filed an affidavit in opposition. Really not opposing, I shall take your lordship to that. But in the meantime, my lord, and the affidavit in reply was affirmed and kept ready. After that, my lord, my father passed away. And so, my lord, I was not aware of that. So when the official liquidator's personnel went there, Then we came to learn, and then, my lord, we approached a new advocate, my lord, and found out that the application for disclaimer was there. So, my lord, I'm now pressing in that, my lord. May I file the affidavit in reply also? It was affirmed way back.
Opposition reply.
Party, I think. No? Substitute.
Substitution has already been carried out.
Affidavit in opposition is not on record.
We shall hand over the copy.
Not on record, your lordship.
But we can give a copy, my lord.
File that because that should be there because.
Well, we can give a copy, my lord.
Copy won't do. I have to have my record straight. It should be on record. There's no order also. Order আছে কিছু দেখি।
Well, order records is just to the for filing. Order records direction for filing.
Yes, so there is no order recording that it is on record. So therefore, there should be something on record for me to take a copy saying that it is not there in the court.
Lordship, in this case, if the opposition, I'm not aware, if the opposition is not there, may I permit you to reaffirm the same and file within a week?
File it because there is a direction for filing affidavit.
Yes, and in fact, my reply is also there. And
The official liquidator's office may have affirmed it and served on you.
yes,
If you to file it in court when the matter.
that has possibly not been filed.
That is why it is not there on record.
So, it may be traced from the records, or if not, my lord, they can.
2 weeks, your lordship, may
One week.
2 weeks, your lordship.
1 week.
By the order dated January 10, 2018,
Well, 13 is my application.
26 থাক না ওটা অটোমেটিকলি করে নেবে ঠিক থাকলে পরে
Well, this is one of the few provisions which has been retained before the High Court. This is original. This was always there with the High Court, and even after the NCLT has been formed, this provision has always remained before the High Court. Well, this is a company petition under section 463.
the other side
We have served, the affidavit of service, because we under the company rules we have to take out the summons before serve, and then we can file the affidavit in support of
but
the
he appears for the registrar.
Normally they sometimes earlier days also when we move earlier it was known as section 633 under the old act. Now it is 463. So we used to then also move those days when the company code was in court number 16. They used to not come on the first day. Now, this is Lordship sees the new act. Lordship has the new act. Or may I hand over my book? May I hand over? ये नहीं वो पुराना है
No, no, 56.
That is nowadays it is not become obsolete. Kindly come to 463. This the power is only with the High Court.
463.
Yes, madam. This has been this has not this power was earlier 633 and it has remained with the High Court because of the consequences. And there are two limbs, 1 and 2. First 463 once applies when the proceedings has already been filed before the court concerned.
The court which is hearing the case?
Yes, which is my case. And 463 subsection 2 is where that case where we come before.
In apprehension.
Yeah, apprehension. Now so this is a 463 one scenario. Now 463 one scenario, kindly very 3 minor offenses are there. Now kindly just read the section 1. It says that because I expect Lordship will put me one simple question.
Why should I?
Yes, I will answer the question before that. Now Lordship said that why have you come here? Yes, why have you come here? Now this says that kindly read the language of 463(1). I've come here for one reason. The offense or if I can use the word mistake is very small and trivial, very small. But be that is may, they have chosen to.
And what is the tenure of punishment? Sentence 1 year or 6 months?
Tenure 129. I'm just giving that in a moment. Kindly read 463(1) first. This is 129 penal provision. If in any proceeding for negligence, default, breach of duty, misfeasance or breach of trust against any officer of a company, it appears to the court hearing the case that he is or may be liable in respect of the negligence, default, breach of duty, misfeasance or breach of trust, but that he has acted honestly and reasonably, and that having regard to all the circumstances of the circumstances of the case, including those connected with his appointment, he ought fairly to be excused. The court may relieve him either wholly or partly from his liability on such term as his tongue's fit. Provided that in a criminal proceeding under this subsection, the court shall have no power to grant relief from any civil liability which may attach. Civil liability means fine. So now Lordship asked me the question. The answer is the applicable section here is an alleged violation of section 129 of the Companies Act, read with Schedule 3, and the offense is means the punishment is imprisonment up to 1 year or fine. Up to 1 year of fine. So fine aspect obviously. Now only we have come here for the threat of imprisonment. Now kindly see the
stage of the criminal proceeding.
They have filed. I have annexed the complaint. Now it is at the stage of SRAD. SRAD. They have already filed. We have annexed the complaint petition also. Now initially what had happened? The original notice they had issued a notice under 2064 of the Companies Act. We are given a reply. When they gave us the notice, there were 15 alleged offences which they have mentioned, which is the notice under 2064. which is dated 25th April 2022, inadvertently, my lord.
Usually appears for the registrar of companies. People who would be representing Union of India should appear.
Yes, because it's under the central government. I was only indicating just one small prayer, my lord. This is the notice which contained 12 offences. Though we have mentioned in the body, inadvertently it was not annexed, so I put it in a one-page supplementary affidavit, which I've got handed over. Kindly see, there were 15 alleged offences from pages 1 to 4. But when they issue us when we gave a reply to this notice, we have given the reply which is annexed to my application, which is at page number 51. After considering my reply from 15, the complaint petition is now limited only to 3. So from 15 minus 3, 12, they have accepted my reply to be satisfactory. So only 3 remains. Now, what are those 3? Kindly come to the complaint petition, which starts at page 44. Kindly come to 45 bottom. Very small offense, my lord. 15 out of 12 gone, only 3 remains. Kindly come to 45 bottom. This is the first one.
Yes.
120. Z with schedule 3. And what is the offense? Kindly come to the next page. They are saying that we have 46. Kindly see. They are saying the company has shown an amount of 37 lakh so and so and 1 comma so and so as other loans under the heading short-term loans and advances. However, the company has failed to specify its nature in accordance to schedule 3. So they are saying that under the heading short-term loans and advances, you have not specified the nature. That is a mistake I have omitted or done. Now, which we have given the reply at the bottom. Kindly see the bottom, they are given company's director auditor's reply in italics. It is humbly submitted that details of loan outstanding so and so have been shown under the heading short-term loan and advances in notes on financial statement in compliance with requirement of so and so relating to it should be general instruction for preparation of balance sheet. Now we have given this, but IO's conclusion at the next paragraph is that they feel it is not satisfactory. So there is no serious offense of any there is any error in accounting. There is no mistake of non-preparation of balance sheet, financial statement. There is no misappropriation of fund, no defalcation of fund, no fudging of accounts. This is one that we have not able to describe the nature of loan. Next, kindly come to the next offense is at page 46 bottom at 47. Here they are saying we have at page 47 in the middle, they are saying that we have not annexed the notes to the balance sheet, which we have admitted we have inadvertently missed out. Lordship knows every balance sheet has a note. So next offense is in balance sheet of 2016-17, we didn't annex the notes. And we have given that it's a mistake, page 47, second last paragraph. We have IO's conclusion is that we have already admitted that inadvertently is missed out in the PDF document, therefore company accepted its mistake. Contravention still exists. Though I've accepted, but on law they exist. So that is why I've come before you for exemption, waiver, and so this proceedings can be dropped. And the third and the last one is at next page at 48. This they are saying that there is a contingent liability which we have not disclosed. 48, kindly come to page 48. This is the last one. The company. First paragraph, IO observation. The company did not provide contingent liability of 120706. And the answer we have given at the bindle, we are saying we have already filed a legal challenge to the demand, and it is appeal is pending before the Commissioner Income Tax.
Demand stayed.
Demand stay? No. It is just pending.
Of the demand if you pay 20% and you.
No, it is not stayed. It is pending. It is pending. So this offense, it cannot be actually categorized as an offense to speak to. If you strictly speaking, these are the 3 minor offenses.
The affidavit of service,
I just handed over. I was only praying, prayer be in the meantime, no coercive steps should be taken. Though I will always, we have already, as the SIAG said, but sometimes, Lordship, what happens, all of a sudden, it converts into a warrant. Unknowingly, we may not be aware. Sometimes, it becomes a warrant. That becomes, then, there is a, दिखाना उसका copy देना, वो affidavit of compliance service का copy देना. Normally, the procedure is we have to hands up क्यों कैसे क्यों? Speed post. Matlab it has been delivered. Delivered date. It has been delivered on 28th July. Kindly come to page 8 and page 6. It has been they both delivered 28th July. Only order in terms of Pre B, my lord, till they come back and file the reply. Pre C, I'm so sorry. Pre C, I'm sorry, it is C. Not to take any coercive steps in the meanwhile. If after filing affidavit, lawsuit finds that.
When did they come to know about this?
My lord, the notice which I have given in this supplementary affidavit that is dated April 25, 2022. We have given a reply on May 16, 2022, and the complaint case was filed in 2024.
So what is the limitation for filing complaint case?
No, the complaint case is within limitation. I'm not taking the point.
Is within limitation.
Yeah, I'm only saying, my lord, because the nature of mistake is very small. We have.
But then if it is within limitation, no matter what the nature of mistake is, if the mistake carries an imprisonment or carries a sentence,
yes,
how will the court unnecessarily, or on what ground will the court just absolve?
That will be the final relief, which is prayer day. I'm not asking today. If
even then,
yes, court has the power.
The present relief which you are asking at the ad interim stage will be the aid of the final relief.
Correct.
Now, if the final relief I am not able to grant, then in that case I will not grant that. So how do I assess?
Correct.
That?
I'm saying that a complaint.
And what will be your answer to the first question that it is to be done before the court who is hearing?
Yes, I'm coming to that. Here, my lord, I've shown you two things. First is the nature of offense. If it is of a very minor nature, but
the authority that if it is minor nature, I can do it. I may not do it because the offense may be, say for example, stealing, theft. Theft is theft. If it is for 1 crore, it's theft. If it is for 2 rupees, it's theft. The punishment may differ.
I understand.
Now, so therefore, the offense remains. Now, there is a category of offenses within which you fall. Now, you want the court to absolve you of those.
That is the final absolution.
Yes, but you have to show authority that yes, I have the authority to absolve. Now, the complaint was lodged in 2024.
Yes.
Your petition is of 2026.
Yes, because now, my lord, the stage is becoming ripe. Earlier now, the moment SI.
Then why interim orders? Let them come and we'll pass orders then.
Then lordship give 2 weeks, we will come after affidavits.
Yes.
And lordship said that interim order is open, we will consider after.
Yes.
As they are not present.
None appears. Affidavit.
Page 22. Page 22. I am not agreed with the order of the RGRO, but RGRO referred, directed, my lord, last but one para, my lord, page 22. The license is also advised, my lord, may I read?
Yes, to raise bill for the month of such and such.
As per physical meter reading, my lord, but they had not followed that.
Yes, Mr. Bandyopadhyay, you
Yes,
have
one
not
of the
followed
last
this.
occasion, you lordship remembers, my lord, they put the allegation that we did not comply with the order of the RGR. My lord, RGRU has said, my lord, that the contract demand load that is to be, my lord, reversed, and it is to be, my lord, it should be 28.371 kVA. Now, my lord, what we have done, we have, my lord, cancelled the previous quotation, we have withdrawn it. Now, my lord, he was requested to deposit the, my lord, outstanding amount, which has, my lord, which is, my lord, rupees 55,788. The reason is, my lord, the service connection was disconnected on, my lord, 20th August 2024. Thereafter, my lord, these proceedings were going on.
Did this 55,000 amount, where, in what, how does it come?
My lord, up to that date of connection, date of disconnection, my lord, this was the outstanding amount.
And what was it?
And he has paid it. He has paid it.
Yes, my lord.
He has paid it. He has paid it on, my lord, the 31st December 2025. Now, my lord, what we have done, my lord, the next, we did not, my lord, raise any, the RGR also directed that the bill should be raised as per the, my lord, meter rating. Now, my lord, we did not raise the any bill amount for that period, the disconnected period. Now, my lord, what we did, my lord, perhaps they have failed to understand the, my lord, the bill raised. My lord, dear lordship, kindly comes, I don't have the pagination. My lord, it should be 22, 3, 4, 5, 26 perhaps, my lord, subject to correction. My lord, kindly see the bill. What we have done, my lord, the LPSC charge for the, my lord, late payment of that outstanding amount that has been, my lord, shown in that bill that they have annexed with this writ petition.
Yes,
We have
42,638.
now, my lord, LPSC charge you will find 11,167.84. My lord, left hand, my lord.
Yes.
That is the LPC charge and the minimum charge. There is no, my lord, consumption charge in that particular bill, because his consumption for the respective period was within the permissible limit, so no charge was, my lord. Now, my lord, we have further inspected the premises, and, my lord, this is industrial connection. We submitted before the RGRO that the contract load was found to be, my lord, 28 point something. And accordingly, the RGRO directed us to, my lord, calculate the charges as taking the contract load as 28. But, my lord, 28. Now, my lord, upon further inspection, it was found that his present load is, my lord, 24.80 kVA. Now, you lords will find, my lord, we have already, my lord, changed the load capacity. His allegation is that we have not changed the meter, we have not changed the line. My lord, that meter was capable of, my lord, taking the load of this enhanced load capacity. So, my lord, meter is not required to be changed. That's why it did not change. Now, my lord, we have further issued a quotation amount, my lord, taking the load as 24.80 kVA. And that quotation is, my lord, the due date for payment of that quotation is, my lord, 31st August 2026. There is time. And that's why, my lord, that amount has not reflected in the current bill. This is the position. So we have, my lord, fully complied with the RGRO order. Even, my lord, we have, my lord, lowered down the, my lord, the load capacity as physical inspection. Subsequently, it was found that it is 24, not 28. But the RGRO directed us for, my lord, 28.
28 what?
28.371 kVA. That was the, my lord, your lordship will find from the order of the RGRO that RGRO directive, the second paragraph starts with accordingly, my last line, contract demand 28.371 kVA instead of 39.89. 39.89 was the, my lord, contract load as shown by the, my lord, WBSC.
Yes,
My lord, the RGRO's final order.
Yes, got it.
Page for the 22.
And, my lord, kindly see page 23, my lord.
Such and such instead of, so RGRO wanted you to do it 28.371 kVA instead of 39.89 kVA.
28.371.
Now
We have made it 24.28,
where do I
24.8.
find, where do I find that?
My lord, 24 point, my lord, connected load is 13.16. No, my lord, the quotation that has been raised, they have not, my lord, quotation that has been raised, in that quotation, we have calculated the amount. That quotation has been sent later.
So they have done that. They have revised
Yes.
the
My lord, kindly, 1 minute, my lord, kindly come to page 23, my lord. Annexure P7, last line, my lord. It is the letter of the station manager who wrote, after reconnecting the service connection, your contractual load will be updated as per the order. My
page
service
23.
connection,
You are reading page 23.
page 23, my lord, last line.
Page 23 is GRO's order.
No, my lord, station manager.
No, page 23 is GRO's order. Station manager is page 24. After reconnecting the service connection, your contractual load will be uploaded.
Yes,
That's
my
your
lord,
reading.
yes. That is my grievance. Till date, they have not done so.
No,
That
he says he has
thereafter,
raised,
my lord, I made
Mr.
another
Bhattacharya,
letter.
he says he has raised a quotation where he has given the new
That he has
quotation.
received. That he has received. Perhaps my learned senior friend doesn't
Your
have the, my
client
lord.
has received the quotation
My lord, do we have?
where it has been revised.
And my lord, thereafter, I made another letter to the RGRO that this is going on. They had not done so. That is
But they
annexure.
have done that, Mr. Bhattacharya. Mr. Bandopadhyay says that he has issued the letter, quotation letter to your client. Your client has received it. That is what his instruction is. Have you taken instruction from your client? Mr. Bandopadhyay, you have a copy of that?
My lord, I have a soft copy. That is the problem.
Soft copy. You give him a copy so that
I can print and supply, or I can send him.
you take a copy from Mr. Bandopadhyay. I think the problem will be solved. Affidavit of service filed
21. I'm for WBS.
Passing it over. Nobody is there unnecessary. They will not come.
Yes, your lordship directed to
ওনার একটা call করে দিন না, একজন কি in person appear করছেন।
the report is ready.
My report is also ready.
Both the parties are there, 24.
No, there is a person appearing in person. Let him.
Other matters.
27.
23, lords.
27.
23 was fast one.
5 minutes are left. He is appearing in person. He wants it to be done. You will be here every day. Do it tomorrow. Yes.
My lord, item 27, I am the petitioner in person. On the last occasion, your lordship directed the opposite party, they were seeking the direction from their client whether he is permissible to pay whether I am permissible to get the electricity connection without paying the security deposit amount, just based on clearing the outstanding amount. So he's standing for instructions.
With deepest respect, I have taken the instructions. So far, the disconnection has taken place. Lordship will kindly appreciate on 5th of November 2024. And thereafter, there was a bill due from June 2024 to, may I hand over so that Lordship can appreciate that.
Yes.
Now, the said supply was, Lordship got that? This connection was taken place on 5th of November 2024. And there was a non-payment of bill from month of June 2024 to September 2024. The bill was incurred. Thereafter, last consumption bill that has been raised against the said consumer was in October 2024, account up to the disconnecting reading. The gross bill amount of October 2024 was 17,188. Kindly mark that.
So he has to pay the security deposit.
Yes, yes. Why? Because why it has been reason has.
I have understood. It
Yes.
has been used.
Yes.
Since your
My lord, may I be interrupted in the middle? My lord, as I shall refer the Electricity Act 2003, Section 47, subsection 1 of the Electricity Act 2003, where it is enumerated that a distribution license is statutorily empowered to require any consumer to provide and maintain reasonable security for the payment of electricity charge. The original security deposit paid by the consumer is not lying intact with the distribution utility, as the same has been already adjusted. So with the arrears. So now, so it is not permissible. I am compelled to pay as per law, I'm supposed to pay the security deposit amount. Now I shall bring your lordship to section 43, subsection 1 of the Electricity Act 2003. Duty to supply on request, as save as otherwise provided in this act, every distribution licensee shall on application by the owner or occupier of any premises give supply of electricity to such premises within 1 month after receipt of the application requiring such supply. And subsection 3 of the 43 says that if a distribution licensee fails to supply the electricity within the period specified in subsection 1, he shall be liable to pay a penalty which may extend 1,000 rupees for each day of default. Now, my lord, I am relying on 3 judgments of Honorable Supreme Court.
Before you rely on judgments and
My lord, in one more thing, my lord.
Wait.
Yes, my lord.
When the court speaks, you should respect the court.
Yes, yes, definitely.
If you respect yourself more than the court, then you can.
No, my lord.
So you please continue and complete.
No, my lord. Your lordship kindly says, I'm frustrated, my lord. Already I'm frustrated, getting frustrated. There is no electricity. I'm getting frustrated, my lord.
Section 43 will apply in a situation where a person is applying for fresh electricity connection or new electricity connection.
Yes.
Electricity connection.
Yes.
You are seeking reconnection of a supply which was disconnected due to non-payment.
Yes. That after 180 days had already expired.
Whatever.
Yes.
Non-payment. Therefore, there are already outstanding dues.
Yes.
So this analogy of yours that for every 1 day delay, they will have to pay 1,000 rupees will not be applicable here. because till such time that you pay the outstanding dues, their liability to supply will not arise. Their liability to supply electricity to you will enjoin them only once you clear the outstanding dues.
Yes.
You have not yet cleared the outstanding dues, therefore they have no obligation to supply electricity to you. This is number one.
Yes.
Number two is the security deposit that was lying with them has been used up, which is why the outstanding amount has come to 13.
Yes, yes.
Not.
Yes.
Otherwise, it would have gone higher.
Yes.
So therefore, the security deposit also has to be made good.
Yes.
Now, there is a provision where under security deposit may be taken even later.
Yes, yes.
That you can rely on.
That I'm
All
telling
these
you.
other submissions that you are making will not come to your aid.
My lord,
Now,
in the meantime, my lord, I want to tell, yesterday I approached the CSC authorities, the cash collection authority official, that I have intent to pay the outstanding dues. Where outstanding dues are there, but and there the cash collection officer, she asked me to approach before the concerned officer and take a written permission to pay the outstanding dues. Since
that you will pay by the
no, I have approached them and they have denied me. They are telling the matter is sub judice. I cannot pay.
That's right, because there is no order of court. The court will direct you to pay, permit you to pay, direct them to accept.
Yes.
But so far as security deposit is concerned, what will you do about it? You have to
My lord, I want to execute a bond before them and I will pay that in installment.
Bond will not do. Security deposit can be postponed for a month, not beyond that. There is a provision for that.
Okay.
Not beyond that.
Okay.
So within 1 month, you will have to clear the security deposit.
My lord, total money, that is 8,800 something, cannot be paid in money in a lump sum. I'm paying either 2 installments, maybe at least be provided, so that within that time frame, whatever your lordship directs.
Dr. Sahara, why don't you consider his case as without treating it as a precedent?
As your lordship.
In 2 installments.
My lord, one more thing.
Let there be an order of the court, otherwise it will be very
Yes,
difficult,
yes.
and it should not set as a precedent. Lordship,
That's
kindly.
why you take instructions. I'll keep it at 10:30 tomorrow. Come with your instructions. It will be easier for the court to direct.
I have a talk with them. I have a talk with them whether the security deposit can be paid by installment. Your lordship knows that some exceptions, in case of exceptional case, that can be done, but so far the security deposit, your lordship is well aware that security deposit has to be paid.
Yes,
I don't know.
so he
That
is
has
not
to be
denying to
paid.
pay.
Otherwise, if he failed to make payment, otherwise then the necessary step should
My
be
lord,
taken.
the licensee,
Let there be a court order instead of dealing the matter.
Yes.
Lordship takes.
my lord, the
dispose
licensee
of
can approach under there are various provisions to recover the outstanding. So they are thinking that I will not pay the security deposit. So legal avenues are there many.
Be entitled to disconnect it immediately.
Yes, yes, that your lordship kindly directs.
Default of the first.
Yes, yes,
But
that
suppose what happened? Suppose the line is lying in their
First
name.
installment will have to be paid along with the first consumption bill.
Yes.
yes.
Along with
No, my lord, kindly take separately.
No. First installment will have to be paid along with the first consumption bill to ensure that the electricity is continued till the next month.
Yes, yes.
And in the next month, by the 15th of the next month, before the second consumption bill falls due, you will have to put in the balance security.
Yes, my lord, one more thing. My lord, I am actually wanting to pay the 50% of the total arrears, what including the security.
Last occasion you said that you will
Yes, because they are adding the security deposit amount and the arrears, that is 22,000 something that is coming. So I am telling that I am paying 50% of the total amount.
That
Ma'am, that Supreme Court, Honorable Supreme Court also has directed in many judgments.
142. I don't have that power. Supreme Court has power under 142.
Yes, yes.
That power under 142. Right. My power is much lower than what the Honorable Supreme Court has. Supreme Court can do that. I cannot do. Don't expect that.
My lord, your lordship kindly directs to pay the arrears and the rest installment security deposit.
I will say.
Yes, yes.
In 2 installments.
Yes, yes.
First one along with the first month's consumption.
Yes, yes.
Second one within 15 days prior to the second consumption bill being raised.
Okay. That will be 2 months, total 2 months. Next
1.5 months.
1.5 months. Yes, yes, yes.
My feeling
Very much grateful to your lordship. Your lordship is giving life to a litigant. Grateful. Yes.
এই কাছে তখন বলা যায়